Okay, good morning, everybody. We're going to get started. Everyone's here and we just received the message to get started, so we're going to start. Let's call the case of State of West Carolina versus Timothy Ray. My name is Judge Reeses. Scoring judges, please look to the two buttons on the left lower of your screen. There you will see that you can turn off your audio and your video. These should remain off until the trial ends. You should also have your video set to hide all non-video participants. This means the only people on the screen right now should be the advocates and me. So if everybody's ready to get started, why don't we have the attorneys make their appearances, starting with the prosecution.
Good morning, Your Honor. My name is Daisy Wilkinson, and this is my co-counsel, Brianna Brill. We represent the people of West Carolina. Your Honor, would you like a statement of the case?
I don't need that, but let's make or have the defense attorneys make their appearances as well.
Good morning, Your Honor. My name is Megan Ledesma, that's L-E-D-E-S-M-A, and I, along with my co-counsel, Cameron Galvan, both represent the defendant, Timothy Ray, in today's proceedings.
All right, good morning, everybody. Prosecution, you did say you had some motions in limine, correct?
Yes, Your Honor. The state has two motions in limine.
All right, why don't you go ahead with those?
Your Honor, our first motion is to bar the defense's expert witness in this case, Major Riley's last two opinions pursuant to Federal Evidence 704B. Would Your Honor like some background?
I don't need the background, but why don't you tell me your argument?
Sure, Your Honor. We have reason to believe that the defense will bring an insanity defense in this case, and in order to prove such defense, they have to prove that the defendant was unable to appreciate the nature, quality, or wrongfulness of his acts, and that he did not act with premeditation or malice aforethought. Your Honor, in the defense's expert witness's last two opinions, she opined that first, the defendant was unable to appreciate the wrongfulness of his acts, and that he did not act with premeditation in that fourth opinion. Your Honor, that goes directly to the ultimate issue and should be barred pursuant to Federal Evidence 704B.
Defense, what's your response to that?
Our response, Your Honor, is specifically that, one, we will not be eliciting any testimony today that goes to the ultimate issue in today's case. We understand the Federal Rules of Evidence 704B, as well as the case given within our local jurisdiction today, Pasquarello. Referring to 704B and Pasquarello, experts in a trial are allowed to testify as to, one, whether a defendant has a mental disease, particularly in this case, schizophrenia, as well as what the characteristics of that disease are. We will not be eliciting testimony regarding the ultimate issue in today's case as to whether the defendant specifically knew what he was doing on October 17th, 2018. We understand that to be the state's burden in today's case, Your Honor. Furthermore, excluding the entire two reports is highly prejudicial in today's case, seeing as the state has also brought an expert who we have a good faith belief will be testifying as to whether the defendant is faking a mental illness, Your Honor. So with that being said, our expert, we also have an expert, and they should be allowed to testify as to whether she believes the defendant is faking a mental illness in the case, and if the defendant is not, what the mental illness is that the defendant has.
Okay, so here's my ruling. We are going to grant the motion in part. The case law is pretty clear that no witness is going to testify, or no expert or anybody is going to testify as to the defendant's mindset. You know, whether he knew what was right or what was wrong. You can absolutely testify to the underlying medical reasoning for whether or not somebody can or cannot appreciate their actions based on their mental disorders. You know, I know it's a fine line, but we're going to stick consistent with the case law. Anybody can bring an objection during the trial if they believe that that motion in limine is being violated or someone is overstepping. But we're just going to stick to the medicine of it and not whether or not that defendant can, or whether or not the defendant actually had a certain mindset or not. That's an issue of fact for the jury.
Yes.
Make sense? Okay. Any other motions eliminated by the prosecution?
Yes, Your Honor. We are moving to exclude any testimony Officer Wentz may give regarding a lay opinion about the defendant's mental health pursuant to Federal Rule of Evidence 701 and 602. Your Honor, any opinion that Officer Wentz gives regarding the defendant's mental state would lack personal knowledge, as Officer Wentz has no way of knowing what was going on in the defendant's mind. Additionally, Your Honor, he's not an expert on mental health. Specifically, Your Honor, we asked to bar Officer Wentz from using words such as crazy, delusions, paranoid, phrases like that, Your Honor.
Response?
Your Honor, first and foremost, Officer Wentz will be testifying as to what he perceived at the time of his interaction with the defendant. We are not calling him as a medical expert, Your Honor, and any testimony that he gives will be based on his rational perception at the time that the event was occurring, Your Honor. We agree that Officer Wentz will not be testifying as to whether the defendant is insane. However, the statements such as crazy and whatnot, Your Honor, are more of the general terms that we use in everyday life to better describe what we're perceiving at the time that we're perceiving it, but it is not meant to indicate as to Officer Wentz medically opining that the defendant was crazy.
Counsel for the defense, don't you think that can be misleading to the jury then? If Officer Wentz is using the words crazy or delusional or things of that nature, isn't that going to sound like he's giving an opinion whether someone is actually crazy? Can't he describe what he's doing or what he saw without using those words?
We understand that it may sway the jury that way, Your Honor. However, that goes to weight rather than admissibility. And additionally, Your Honor, it's more probative than any prejudicial effect that it may have, because it helps the jury understand, one, why we're calling Officer Wentz in today's case, and second, how to evaluate his opinion versus the opinion of Detective Booth, who we rationally believe will be testifying that there was nothing wrong with the defendant, particularly at the time that he was brought in that night. As well as the other evidence indicating that the defendant may or may not be lying and why. So we believe its probative value substantially outweighs any misleading or potential prejudicial effect, merely because it helps the jury better understand and evaluate the evidence in today's case.
I'm going to reserve my ruling on this. I think the context is going to be key. I agree, maybe just using the word crazy isn't indicative of an opinion. But we're going to see what he says. And counsel for the prosecution, you can make your objection at the time if you think they overstep and they're really giving an opinion rather than kind of qualifying, his opinion on it or his viewpoint of the actions.
Yes, Your Honor.
All right. Any other motions by the prosecution?
No, Your Honor.
Any motions by the defense?
No, Your Honor. Defense is ready to proceed with opening statements.
Okay, 1 second here.
Your Honor, the state has a few housekeeping motions.
Oh, yes, I'm sorry. Go ahead.
Your Honor, may we move about the courtroom as long as we're within the Zoom screen?
Yeah, move as you guys like.
May we use an exhibit during our opening statement? We've already spoken to opposing counsel and they indicated they have no objections.
If there's no objection, there's no objection from me.
To clarify, Your Honor, we did agree that we will not object to the exhibit being used in opening, but we did not stipulate that it is admissible for the rest of trial, just to clarify.
Well, then let me ask something about that. What is an exhibit like a demonstrative that you created, or is it a piece of evidence in the trial?
Your Honor, there is a piece of evidence in the trial and there's also something that we created.
Okay, and you're allowing them to use both, correct? Defense?
We were instructed that they would be using 2 exhibits during opening. I'm not sure what the demonstrative was to be used for opening. I do understand that they were using a demonstrative throughout the trial as well as closing statements. If we could just clarify that really quickly.
Yeah, go ahead, guys.
Your Honor,
I don't want someone to object during their opening, so.
Your Honor, we showed opposing counsel yesterday all the items we were using in open.
I remember specifically bringing 2 exhibits in opening. If you could just tell me, I remember what we saw. You could just tell me what it was, the demonstrative for opening statements.
My co-counsel is opening, so I'm sure she'll.
We're using the exhibits of the picture of the photograph of Nathan Ray, as well as exhibit 10, I believe, of the trash bag photo of him.
Yes, that's what we understood. We were not aware of a demonstrative. So is a demonstrative going to be used during opening?
No, just the,
Okay. Well, then yes, Your Honor, that is what we understood from yesterday's meeting, and as well as the fact that we are not stipulating it's automatically admissible throughout the rest of the trial, but we did agree,
Right.
yes, to being used.
Okay, that makes sense. Okay. Any other motions or housekeeping from the prosecution or defense?
Yes, Your Honor, just a few. We plan on calling an expert witness in our case in chief. Would you like us to lay foundation and then formally tender the expert, or just lay foundation and then continue on with the testimony?
Both. Formally tender him and lay the foundation.
Your Honor, pursuant to Federal Rule of Evidence 615, we ask that all non-party, non-essential witnesses are constructively excluded from the court.
Any objection to that?
No objection, Your Honor. However, we would like to clarify that our expert will be allowed to constructively remain inside the trial throughout the proceedings.
Yep. Any objection to that, prosecution?
No, Your Honor.
All right, so that motion will be granted.
May we assume that all witnesses are constructively?
Yes.
Your Honor, as you are aware, we are having today's trial via Zoom. Because of that, would you like us to lay foundation for exhibits by having the witness reference the electronic notebook? Or would you like us to display the exhibit on the screen while we lay foundation?
Whatever is easier for you guys, totally up to you. I think the electronic notebook is probably going to be easier rather than having to, pop it up. Whatever you guys want to do, totally fine with me.
Last thing, Your Honor, in reference to the pretrial orders listed on page 4 of the electronic notebook, we wanted to make the court specifically aware of order number 9. This order states the state is not permitted to present any rebuttal witnesses. The state must call its witnesses in its case in chief. The defendant may not object to the state calling Dr. McLaGreca in its case in chief to testify about the insanity defense on the grounds that the defendant has not yet presented evidence of the insanity defense. The court reserves all the rulings regarding Dr. LaGreca's testimony for trial.
Got it.
And that's it for housekeeping, Your Honor, for the state.
Any housekeeping issues for the defense?
Just a few, Your Honor.
Whenever you're ready, counsel.
Just to clarify, pursuant to today's proceedings, we will be using the Federal Rules of Evidence.
Yep.
Your Honor, may we stand while directing and crossing witnesses?
You can do whatever you like in your little Zoom box.
Because of the manner in which this trial is being constructed, may we assume that all sidebars, when requested, are made constructively outside the presence of the jury?
You may.
And there are several potential exhibits that can be found throughout today's trial record. These exhibits have been pre-marked for identification purposes. We ask that the exhibits retain their markings throughout the course of the trial to avoid any potential confusion or inconsistencies.
If prosecution wants to remark something for any reason, I'm going to allow that, but I agree that would be easier.
Yes, Your Honor. And Your Honor, may we assume that the jury charge has been read prior to closing arguments?
Yeah.
That concludes the defense's housekeeping, Your Honor.
All right.
Your Honor, actually, if I may.
Yeah, of course.
There were 2 more points of clarification that the defense has forgotten to prove up in housekeeping. Yes, first is that we have already conferred with opposing counsel about using a demonstrative in our case in chief, and opposing counsel agreed to it.
And by case in chief, you mean your opening?
No. A demonstrative within our case in chief later. Yes.
Okay. Yeah.
Yes. Additionally, because of the nature of today's trial being online and over Zoom, my co-counsel and I will be switching rooms depending on who is actually presenting. And I just wanted to clarify in case you see any switch of background.
No, I appreciate that. That's fine. If for any reason you're switching something or another and you need a minute, just tell me. That's okay. For the timekeepers, make sure you're actually stopped, but just make us aware that, hey, Your Honor, we need 10 seconds to switch or whatever it is. That's fine. Just make us aware of any issues. That goes for everybody. If somebody realizes that their partner or the person they're, crossing, directing, whatever it is, freezes or something like that, just, it's okay if you're just, hey, butt in, Your Honor, I think someone's frozen. We have to move. We have to do this. We have to do that. You guys are doing a good job making it work over Zoom. So, you absolutely deserve the benefit of the doubt if some hiccup happens. So, any other issues from the prosecution or defense before we start?
No, Your Honor.
All right. So we will now hear opening statements from each party. Everyone should make sure that they are in speaker view. That button is in the upper right of your screen. Attorneys, please remember to mute your audio when the other attorney is speaking. And if everyone has done that and ready to go, prosecution, go ahead with your opening.
Your Honor, if I may have like 10 seconds to switch with my co-counsel, he will be doing the opening statements.
Yeah, absolutely.
May it please the court, counsel, ladies and gentlemen of the jury. This was Nathan Ray, a young boy who attended Skelton Elementary School and was a Carolina Panthers fan, a 6-year-old child who liked to play soccer and who loved to play with his choo-choo train, the Nathan Express. Unfortunately, you won't get to meet Nathan today. Why? Because you will learn his father, the defendant, strangled him to death on October 17th, 2018. Ladies and gentlemen, you will learn that the defendant put vengeance against his wife over the value of his son's life. Good morning. My name is Daisy Wilkinson, and along with my co-counsel, Brianna Brill, we represent the people of West Carolina. Members of the jury, a parent is supposed to protect their child from harm, not create it. A parent is supposed to give life, not take it away. But that's not what the defendant did. The evidence will show that the defendant took the life of his only child when he punished him, strangled him, and murdered him. You will hear about the defendant's heinous actions today. We will call Detective Blake Booth, the lead homicide detective who investigated the murder of little Nathan. Now, ladies and gentlemen, pay attention to his testimony because he will tell you the exact steps the defendant took to plot, strangle, and kill his son. It started off like any other day. That morning, Nathan was having a bowl of cereal and some apple juice. And right before it was time for Nathan to head off to school, he accidentally spilled his juice. And the defendant became enraged. I want to be very clear about something, ladies and gentlemen. The defendant wasn't upset because his son spilled some apple juice. No. The defendant was upset for reasons that had nothing to do with little Nathan. You see, the defendant had recently learned that not only was his wife cheating on him, but she had left him. And the defendant was afraid that she was gonna take Nathan away from him. So in this moment, fueled by anger and resentment, the defendant took out his frustrations on his innocent son. Members of the jury, you will hear how the defendant punished Nathan by making him do extreme and exhausting military exercises until his 6-year-old child was crying and screaming in pain. But that wasn't enough for the defendant. He wanted to do more. So the defendant then went to his bedroom. He sat on his bed and he thought about exactly how he was going to get back at his cheating wife. So the defendant then got a belt and he went back into Nathan's room. And he started beating his son, whipping him with that belt over and over. But once again, that wasn't enough. Members of the jury, you will hear in the defendant's own words the next steps he took. I put the belt around his neck. I pulled the belt until he stopped screaming, until he stopped moving. Ladies and gentlemen, the defendant watched his own son struggle, gasping for air as he pulled the belt tighter and tighter until Nathan was dead. The defendant confessed to killing his own son. And if that wasn't enough, you will learn how the defendant tried to cover up his heinous crime. The defendant put his son's body in a trash bag, drove around with the corpse in the car, and then dumped it like he was throwing out a piece of trash. Ladies and gentlemen, the evidence will show that this wasn't some accident committed by an ill man. This was a cold-blooded killing committed by a murderer. We will prove to you today, members of the jury, that on October 17th, 2018, the defendant intentionally killed his only child, Nathan Ray. And at the end of this trial, my co-counsel, Brianna Brill, will come back before you. She'll ask you to return a verdict that tells the defendant he can't hide behind any excuses, that there's no justification for killing your own child. A verdict that tells little Nathan Ray his life was worth more than his father's desire to get back at his wife. Return a verdict of guilty.
Okay, defense, go ahead with your opening statement.
Yes, Your Honor. Defense is ready to proceed with opening. Your Honor, opposing counsel, members of the jury. When a parent kills a child, we ask, how could that happen? Why did that happen? As a matter of fact, me and my co-counsel, Ms. Megan Ledesma, asked ourselves that many times. How could this happen? It's shocking. It's horrible. It's crazy. It's insane. And we kept asking ourselves how and why until we met Timothy Ray. We learned a little bit about Timothy, and we learned that he's different than you and I. We learned the story of Timothy Ray. And members of the jury today, we are going to tell you that story. Undiagnosed, untreated, and an unexpected tragedy. October 17, 2018 did start out like any other day. Timothy had fixed Nathan a bowl of cereal for breakfast, and everything was fine. Until all of a sudden, a cup of apple juice spills. Now, remember how I told you Timothy Ray was a little bit different than you and I? Well, here's why. The evidence will show that for quite some time, even as early as 10 years old, Timothy Ray had been hearing voices. And today, these voices returned with a different message. The evidence will show that as soon as that apple juice spilled, the voices said, you know that's sabotage. You know he's trying to sabotage you. And Timothy tries to calm down, and he sends Nathan up to his room to do exercises. But the voices come back. They get louder and louder, and the evidence will show that the voices, as they got louder and louder, they came with a different message. Kill him, strangle him. Kill him, strangle him. And Timothy tries to fight off the voices, and he goes to his room and sits and contemplates. But the voices come back louder and louder. Kill him, strangle him. And that one thing to make a parent kill their child, how and why did this happen? Here's why. The evidence will show that the voices became too much and got so loud. Kill him, strangle him. And it was too much. And Timothy Ray couldn't fight him anymore and gave in. Nathan was killed. But members of the jury, it is going to be clear at the end of today's trial that it was not by Timothy. It was by schizophrenia that took not one, but 2 lives in this community. Now, a while ago, opposing counsel came up to you and they told you that they were going to show you evidence. They were going to explain to you and prove to you that Timothy killed Nathan with premeditation and with malice aforethought. But here's the thing. They have to prove that to you beyond a reasonable doubt. Now let's talk about that. Beyond a reasonable doubt is the highest burden in our legal system. That means that you will have to rely on that evidence without hesitation. But let's say we get to the end of today's trial and you believe it. You believe that at the end of the day, Timothy killed Nathan with premeditation and malice aforethought. Then defense asks you to consider the affirmative defense of insanity. There's a reason why our legal system allows for insanity. Because yes, tragic things happen. However, when somebody loses control of their mind and their actions, tragedy happens. And it's not limited in the forms that it takes. And today, tragedy took the form of schizophrenia, a horrid mental illness. We have to prove insanity to you 2 ways. The first way is to explain to you that Timothy Ray suffered from schizophrenia on the day of the incident. And 2, because of that schizophrenia, he couldn't understand what he was doing. But we have to show that to you by clear and convincing evidence. This is not the high burden like the prosecution has. Our burden is much lower. You see, clear and convincing evidence is just merely highly probable that we have to show you that Timothy had schizophrenia, and because of that schizophrenia, he didn't understand what he was doing. Undiagnosed, untreated, and unexpected tragedy. That's the story of Timothy Ray. And we're going to help tell you the story of Timothy Ray with 2 witnesses. You're going to hear from Officer Peyton Wentz. And I want you to pay close attention because Officer Wentz is someone who would normally be testifying for the prosecution. Now, why is he not testifying for the prosecution? Why is he testifying for the defense? Well, it's because he's going to come and tell you he never saw anything like this before. One moment, Timothy is complying with Officer Wentz's questions and orders. But then all of a sudden, Timothy turns around and is accusing Officer Wentz of being in the CIA. And the behavior suddenly changed. Officer Wentz had never seen anything like it before. Then we are going to take all those experiences and direct examples and bring it to Dr. Shane Riley. Now, Dr. Shane Riley is a longtime forensic psychiatrist, very strong in her field with several publications that have been peer-reviewed and even served as a psychiatrist for the United States Army. She is going to explain and break down schizophrenia for you. She is going to define it. She's going to tell you how it looks. And then she's going to tell you why Timothy has severe schizophrenia. I also want you to remember that her testimony is very important because she saw Timothy not once, but twice. Once in 2010 when he was still in the military, and then again in 2019, where she had availability and access to years of medical history, also conducted different interviews with different individuals, and even saw Timothy again. But then you're going to hear from the prosecution's witnesses. Let's talk about them. First, you're going to hear from Detective Blake Booth. Now, she served the community of Skelton well. However, she knew Timothy a little bit before this incident even happened. And you're going to hear her testify and talk about that when she saw him, she thought he was unkempt and dirty. And when she took him for an interview, she didn't follow her directives. All she did was yell and cuss at him. Then you're going to hear from Dr. Mac LaGreca. Now, Dr. LaGreca, again, is a forensic psychiatrist that is very well knowledgeable in her field. However, it's going to be clear to you, members of the jury, Dr. LaGreca did not do enough. She didn't conduct any interviews. She didn't do any research. All she did was read reports and make an opinion.
But at the end of the day, it's up to you, members of the jury, to weigh and balance the evidence. But I want you to remember the presumption of innocence, that every defendant who comes before you is innocent until proven guilty. And the prosecution has to prove that beyond a reasonable doubt. So hold them to it. Our hearts break with the Ray family for this loss. It is very sad and tragic what has happened. But at the end of today's trial, it's going to be clear to you that when Nathan was killed, it was not by Timothy. It was by schizophrenia. And nobody benefits when someone is sick. So we ask that you help Timothy and you find him not guilty or not guilty by reason of insanity. Thank you.
Thank you, counsel. All right, before the state calls its first witness, I will ask that everyone switch to gallery view. That button is in the upper right of your screen. This will allow you to see the attorney and the witnesses at the same time. Okay, so prosecution, you may call your first witness.
The prosecution calls Detective Booth to the stand. May I proceed?
You may.
Good morning. Please introduce yourself to the members of the jury.
Good morning. My name is Blake Booth. For the record, last name Booth.
What do you do for a living?
I'm a detective with the Skelton Police Department. My badge number is 3681.
How long have you been employed at the Skelton Police Department?
For 23 years now.
How long have you been a detective?
Quite a while, 7 years now.
Detective Booth, can you describe your progression through the Skelton Police Department?
Sure, absolutely. So I started as a patrol officer for the Gang Violence and Narcotics Unit. That was back in 1997. Then I was promoted to a detective in that same unit. And I stayed there for about 4 years. And then in 2017, I was promoted and I moved to the homicide unit as a detective. I've now investigated 12 homicide cases.
Detective, what kind of responsibilities does a homicide detective entail?
Well, I investigate murders. So I do all the work from, interviewing the witnesses and the suspects to processing the crime scene and collecting evidence.
Were you a homicide detective in October of 2018?
Yes, I was.
I want to now turn your attention to October 18th, 2018. Do you recall receiving a phone call that day about a missing child?
Yes, I do.
Who was that missing child?
It was Nathan Ray.
Were you then assigned to investigate the whereabouts of Nathan Ray?
Yes, I was.
What was the result of that investigation?
Well, the defendant, Timothy Ray, he confessed to killing his son, Nathan Ray, on October 17th, 2018.
Do you see the defendant in this courtroom today?
Yes, I do.
Can you identify the defendant by an article of clothing they are wearing?
Yes, he's the man on screen with the white shirt and the red tie, and his name is defendant, and it says Timothy Ray next to it.
Your Honor, let the record reflect the in-court identification of the defendant.
Record will reflect it. Go ahead, counsel.
Detective, I want to now start at the beginning of your investigation. When did you receive that phone call about Nathan?
It was about 4:05 in the afternoon on October 18th.
Who called you?
Nathan's mother, Jessica Ray.
What did Jessica tell you?
She said that afternoon she went to go pick up her son from Skelton Elementary School, but he wasn't there.
What, if anything, did Jessica do when she realized her son was missing from school?
Well, she went to talk to the teacher, and the teacher actually told her that Nathan hadn't even been at school for the past 2 days.
Did you learn who the last person Nathan was with before he went missing?
Yes, I did. He was last seen with his father, the defendant, on October 16th.
Did Jessica try to contact Nathan's father?
Objection.
Basis?
Your Honor, if we may move outside the presence of the jury.
We can, moving forward, could be constructively outside the presence of the jury.
Yes, Your Honor. Your Honor, objection to speculation.
Defense, or prosecution, what's your response?
Your Honor, this is not speculation. Jessica is Nathan's mother. Nathan is either in the custody of her or her husband, Timothy Ray. Because he was not in the custody of Jessica, she knew that he was in the custody of Timothy Ray.
The objection is overruled. You may proceed, counsel.
Detective, when Jessica learned the last person Nathan was with was his father, did she try to contact his father?
Yes, she absolutely did. She called the defendant multiple times and then she went over to his house.
What happened once Jessica arrived at the defendant's home?
Well, she didn't find him there, and Nathan wasn't there either, actually.
At this point, did Timothy Ray become a suspect in the disappearance of Nathan Ray?
Oh, yeah, absolutely.
Did you ask Jessica for any information about the defendant in order to locate him?
I did, yes, and she gave me a description of his physical appearance. She also gave me his address and a description of his vehicle.
Did Jessica provide you a description of Nathan as well?
She did, yes. I learned that Nathan was a 6-year-old white male, and he was about 3'9". He had light brown hair and green eyes. Additionally, I learned what he was wearing the day of his disappearance. He was wearing a red t-shirt, blue jeans, and a Carolina Panthers zip-up hoodie. Jessica actually also provided me with a photo of Nathan Ray.
For the record, directing everyone's attention to what's been previously marked as Exhibit 29, page 106, that's been previously marked as page 109, 106 for identification purposes. Detective, do you recognize Exhibit 29?
I do, yes.
What is it?
This is the picture of Nathan Ray that his mother gave me.
Is this a true and accurate copy of a photo of the victim in this case, Nathan Ray?
It is, yes.
Your Honor, permission to admit Exhibit 29 into evidence.
Any objection, defense counsel?
No objection, Your Honor.
All right, it'll be so admitted. Go ahead.
And permission to publish it on the screen for the members of the jury.
You may.
Detective, taking a look at Exhibit 29, does this photograph accurately depict what Nathan Ray looked like in October of 2018?
Objection,
Yes.
Your Honor.
Sorry, basis?
Objection to speculation.
Speculation about what, counsel?
Well, Your Honor, if we may move outside the presence of the jury.
We're constructive, for all objections moving forward, we're constructively outside the presence of the jury.
Yes, Your Honor. Your Honor, Detective Booth has no way of knowing what Nathan looked like during October of 2018, only that there was a photo given to him by Jessica Ray. Aside from that, she has not testified that she's seen Nathan in October of 2018, so she has no way of knowing if that's what he looked like.
Let me ask you this, counsel. Do you contest whether or not that's what Nathan Ray looks like in October of 2018?
No, Your Honor, just that Detective Booth should not be able to testify that is exactly what he looked like during October 2018. We don't know when the photo was taken. We just know that was a photo provided to Detective Booth by Jessica Ray.
Okay, the objection is going to be overruled. You may proceed, counsel.
Detective, does this photograph accurately depict what Nathan Ray looked like in October of 2018?
Yes, it does.
Detective, after you spoke with Nathan's mother, what did you do next in your investigation?
Well, I drafted a missing persons report for Nathan. I included a description of Nathan and additionally a description of the defendant.
Did you receive a response to that missing persons report that you issued?
Yes, actually the very next day, October 19th, I received a call that a suspect flagged in my missing persons report was stopped at a sobriety checkpoint.
Well, let's turn to October 19, 2018 then. Approximately when did you receive this phone call?
It was about 9 p.m. at night.
And when you received this phone call about a suspect, what did you do next?
Well, I immediately drove over to the sobriety checkpoint on Route 22. It's right outside of Skelton.
What happened once you arrived at the checkpoint?
Well, when I pulled up, I saw the defendant sitting on the side of the road. He was already in handcuffs, and then I saw his car as well on the side of the road.
Did you speak with anyone at the checkpoint?
I did, yes. I spoke with Officer Wentz, and he told me that he ran the defendant's license plate, and that's how he learned that the defendant was wanted in my missing persons report.
Did Officer Wentz tell you anything else?
He did, yeah. He told me that when he looked in the backseat of the defendant's car, there was a shovel with some red liquid substance on it, and then there was 2 bottles of bleach and trash bags.
Objection, Your Honor.
Basis.
Objection for hearsay.
Counsel, what is your response?
Your Honor, Officer Wentz is a party opponent, so this is not hearsay. These are statements by a party opponent.
Counsel, what is your response to that, defense?
Well, Your Honor, yes, it is true that Officer Wentz is testifying for the defense, but at this point in time that opposing counsel is going through, Officer Wentz is not on the side of Timothy Ray. Officer Wentz is the officer that arrested Timothy Ray. So at this point in time, he's not the party opponent.
I'm going to agree that Officer Wentz is not a party opponent just because he works for Skelton Police Department. But I believe that this evidence is not being offered for the truth of the matter started. I think it's being offered more for the effect on the listener, namely what the Officer Booth did in his investigation. So I'm going to overrule the objection at this time.
Yes, Your Honor.
Detective, once Officer Wentz told you what he saw in the defendant's car, what did you do based on that information?
Well, I went over to the vehicle and I looked and I did see those things, so I impounded the vehicle and then I searched the vehicle later.
Did you recover anything from the defendant's vehicle?
Yeah, I did. I actually recovered all of those objects that Officer Wentz stated. I recovered the shovel, 2 bottles of bleach, and the trash bags, and then I took pictures of them for inventory.
Detective, going back to the night of October 19, 2018, after you spoke with Officer Wentz, what did you do next?
Well, I told the defendant that we were going to take him down to the station for some questioning.
Did the defendant say anything to you at this point?
Yes, he did. He told me that he wanted to tell me everything, so.
What happened once the defendant arrived at the station?
We placed him in an interview room.
Did you then question the defendant?
I did, yes.
Now, Detective, before you questioned the defendant, did you advise him of his rights?
Absolutely. I advised him of his rights. I provided him a written copy as well as I actually read them to him. And the defendant signed next to every Miranda right, stating that he understood and wished to waive those rights.
After the defendant signed the Miranda right form, did you then interview him?
I did, yes.
What did the defendant tell you during that interview?
Well, he told me that on October 17th, 2018, Nathan was staying at his house with him, that he had made Nathan breakfast that Nathan was eating before school, and then Nathan spilled juice on his work laptop. Then at that point, the defendant said that he yelled at Nathan and then punished him just for spilling the apple juice.
How did the defendant punish Nathan?
Well, he made Nathan do like extreme military exercises. I mean, crazy stuff. And he told Nathan that he couldn't stop until he told him to.
Then what did the defendant say happened?
Well, Nathan began crying and screaming, and he stopped doing the exercise, so the defendant just decided to punish him even more.
How so?
Well, the defendant went to his bedroom, and he sat on his bed, and then he went and he got a belt, and then he went back and hit Nathan multiple times with the belt.
Where did this occur?
In Nathan's room.
Detective, after the defendant hit Nathan multiple times with a belt, what did he do next?
Well, I mean, Nathan just was crying uncontrollably, so the defendant told him to shut up. And then Nathan just kept crying, so the defendant put the belt around his neck, and then he pulled the belt until Nathan stopped screaming.
Did Nathan stop screaming?
Yes, I mean, the defendant said that Nathan stopped moving completely.
Detective, did the defendant admit to killing his son?
Objection, Your Honor.
Basis.
Leading.
Overrule.
Detective, did the defendant admit to killing his son?
Yes, he did.
Did you learn what the defendant did with Nathan's body after the murder?
Yes, he put his son's car in, or excuse me, he had put his son's body in his car and then he drove around for a few days. Then eventually he said he buried his son's body in Brandywine State Park.
Did you search Brandywine State Park for Nathan's body?
Yes, myself along with a search team. We searched Brandywine and then we actually found the black trash bag partially covered.
For the record, directing everyone's attention to what's been previously marked as Exhibit 19, page 96, for identification purposes. Detective, do you recognize Exhibit 19?
Yes, I do.
What is it?
It's a photo of the black trash bag that I found in Brandywine State Park.
Is this a true and accurate copy of one of the photos you took of the black trash bag you found in Brandywine State Park?
It is, yes.
Your Honor, permission to admit Exhibit 19 into evidence.
Any objection?
Yes, Your Honor. Objection.
What is your objection?
Your Honor, there are two objections under Federal Rule of Evidence 403. Your Honor, first is to the objection of cumulative. Your Honor, this evidence is cumulative because Detective Booth has already testified what the body looked like, that they found it partially covered in a trash bag. Your Honor, there is no need to go into any further statements about this, about how the body looked. All that is going to do is simply elicit inflammatory statements that would just inflame the jury. Additionally, Your Honor, objection to relevance, that it is substantially more prejudicial than probative, Your Honor. And again, it is because Detective Booth has already testified about this, and any further statements would simply be to inflame the jury.
I think that the prosecution has to prove their case. In order to do so, they have to admit this piece of evidence. So while your objection is well noted, it's overruled.
Your Honor, if I may be heard.
Sure.
Your Honor, the elements of the prosecution's case is premeditation and malice aforethought, not to prove how the body looked. They have already shown that the body was found dead in a trash bag. There is no need to further on go with statements that are simply to inflame the jury, Your Honor.
The burden is to prove that he physically killed him, and this evidence shows that he physically killed him. So I'm going to allow it.
Permission to publish Exhibit 19 on the screen.
You may.
Detective, once you found this partially covered trash bag, did you find anything inside?
Yes, unfortunately, we found the body of Nathan Ray.
Once Nathan's body was recovered, where was it taken?
We took it to the Skelton County Medical Examiner's office, and then an autopsy was conducted on it. That was on October 22nd, 2018.
Did you review the results of this autopsy?
Yes, I did.
What were the results?
Well, the medical examiner concluded that Nathan did die by homicide and that the specific cause of his death was by strangulation.
Detective, I want to now focus on your investigation after Nathan's body was recovered. Did you find any other evidence during your investigation?
We did, yes. We recovered the defendant's cell phone.
Who recovered the defendant's cell phone?
Skelton Police Department investigators.
Where was it recovered?
From the defendant's items.
Once it was recovered, were you able to confirm that it was indeed the defendant's phone?
Yeah, absolutely. I mean, it had his Apple ID inside the phone and it identified him by name. It said Timothy Ray.
Once the phone was recovered, where was it taken?
We took it in for a forensic examination.
Did that forensic examination reveal anything?
Yes, it did. It revealed 3 Google searches on the phone, and they were conducted by the defendant on October 18th, 2028.
For the record, directing everyone's attention to what's been previously marked as Exhibit 10, page 57, for identification purposes. Detective, do you recognize Exhibit 10?
Yes, I do.
What is it?
These are 2 screenshots of the defendant's phone.
When were these screenshots taken?
They were taken on October 22nd, 2018.
Is this a true and accurate copy of the screenshots taken of the defendant's phone?
Yes, it is.
Your Honor, permission to admit Exhibit 10 into evidence.
Any objection, counsel?
Yes, Your Honor. 2 objections.
Yep.
Your Honor, first is objection to hearsay on the entire document. And the second is on speculation on the argument that nowhere does it say Timothy Ray
is the one who made the searches. It is on his phone, yes, and that is fine, and we can tell from this, but it does not say, or nor is there any evidence to show that Timothy is the one who made these searches.
Prosecution, what's your response to each of those objections?
Your Honor, this is not hearsay. This again is a statement by a party opponent, the defendant in this case. This is also not hearsay because they're not being the statements on this exhibit is not being offered for the truth of the matter asserted, particularly the searches that were conducted. Rather, it's to show the effect on the listener, the effect being what the defendant did after he killed his son. And we don't care if the statements in the searches are true. We only care about the actions he took after the crime occurred. As for speculation, Your Honor, one, it's already stipulated on page 5, stipulation number 9, that this was indeed the defendant's phone. Further, during the forensic examination, it was revealed that these searches were conducted on October 18th, 2018. During the defendant's interview with Detective Booth, he told Detective Booth that he was alone on that date. It was the day after he killed his son, and he told Detective Booth he put his son in his car and he drove around for a few days. There's no other evidence that the defendant was with anyone else on October 18th, 2018.
So I agree with you on the speculation or the foundation issue, but when it comes to the hearsay objection, you're saying that you're not arguing the searches for the truth of the matter asserted?
Your Honor, it's not for the truth of the matter asserted because it shows the effect of what the defendant did after the crime occurred. And further, even if it is for the truth of the matter asserted, it's not hearsay because these are statements by a party opponent.
I will overrule the, oh yeah, go ahead. You can have one last comment. Oh, if you said anything, counsel, I'm sorry.
Well, Your Honor, again, I would reassert both of them, but both even to the speculation, because again, nowhere in the interview between Detective Booth and Timothy Ray does it say that Timothy was alone the entire day. So again, I understand, yes, it is on Timothy Ray's phone, but there's no evidence, and nor will anyone be able to testify that Timothy Ray himself made the actual searches. And again, Your Honor, they are offering it for the truth of the matter asserted, because if not, there's no other reason to assert them, Your Honor. It cannot be for the effect on the listener, mainly because they are offering to show that Timothy Ray is the one who actually made these searches and made these searches for a purpose. So they are trying to show that he is the one who made those searches. So it is for the truth of the matter asserted.
I'm going to overrule the hearsay objection because they are admissions by a party opponent. The speculation objection is well noted, but I believe that evidence has been laid that the defendant was alone, and I think that if the jury wants to give it a different weight or not believe it, that's their prerogative. So I think it goes to weight, not admissibility. So I'm going to overrule the objections.
Yes, Your Honor.
Permission to publish Exhibit 10 on the screen.
You may.
Detective, taking a look at Exhibit 10, what was the first search conducted by the defendant?
Countries that don't extradite for murder charges.
What was the second search?
How to get rid of a body.
What was the third search performed by the defendant the day after he killed his son?
Will bleach destroy a body.
Detective, I want to now take you back into the interview room that night with the defendant. During that interview, did the defendant express any remorse?
Yeah, of course he did. I mean, he told me, I didn't mean for any of this to happen. I didn't mean to kill him.
Nothing further.
Ross?
Yes, Your Honor. Cross. Detective Booth, I have some questions for you. Detective, you just testified on your direct that you made searches of the phone, right?
That the police department, the Skeleton Police Department made the searches, yes. No, I mean that we made a forensic analysis, yes, if that's what you mean, not the searches, the Google searches.
And the Google searches were found on Timothy Ray's phone, right?
Yes.
But you can't say with 100% certainty that Timothy Ray is the one who made those searches, can you?
No, but he was the only one with his phone on that date, as far as I know.
But that's a no.
Yes, that's a no.
You also conducted searches of the house, is that correct?
The Skelton Police Department did, including myself, yes.
Yes, and you were there. You took photos of the spilt apple juice, right?
Yes,
You also took photos of Nathan's bedroom, is that correct?
we did, yes.
But you didn't take a photo of the laptop, right?
No, we did not.
Detective, you just testified on your direct that you were the one who conducted the interview with Timothy, is that correct?
I did, yes.
You, however, I want to take a step back. You knew Timothy Ray before the incident happened, right?
Yeah, I did. I met him in August of 2018. My kid played soccer with his.
Mm-hmm. And you would see him at the soccer practices.
Yes.
But you thought he was socially awkward there, didn't you?
Yeah, I mean, he wasn't that cheerful. So yes, he was a little bit socially awkward.
And you also thought he looked dirty and unkempt, didn't you?
Yes.
Now, going forward to the interview, and you conducted that interview yourself, correct, with Timothy Ray?
Yes, sir.
And Timothy told you what he did to Nathan, did he?
He did, yes.
And that made you upset.
Well, I mean, yes. Hearing that somebody strangled their son to death, that did make me upset, yes.
That's right, and it made you angry, didn't it?
I mean, I was upset. I wasn't angry, but it was frustrating, yes, to hear that.
So it made you upset and it was frustrating, correct?
Yes, sir.
So you're upset, you're frustrated, and you called Timothy a piece of shit, didn't you?
I did, yes.
So you called Timothy a piece of shit in this official interview, and you told him he's better off dead, right?
I did, yes.
Detective, would you agree with me that that's not proper behavior for a detective at the department?
I can't speak on what proper behavior for everybody is. That's how I conduct my interviews.
So would you agree with me, though, that yelling and cussing at an interviewee is not proper behavior, is it?
Objection
Correct.
asked and answered.
That's going to be granted or sustained.
Detective Booth, a while ago on your direct, you testified that you had a phone call with Jessica Ray, right?
I did, yes.
And you testified that she was crying, correct?
I'm not sure that's what I testified to, but she was very, very hysterical on the phone, yes, after I told her her son died.
She was crying, and like you just said, she was hysterical, and she was also sobbing uncontrollably, wasn't she?
Yes, she was very upset to hear the death of her son.
Yes, she was. And she even told you, I knew I should have never left Nathan alone with Timothy. He was acting strange.
Objection, hearsay.
Response, counsel?
Your Honor, I have already laid the predicate for an excited utterance under 8032.
And prosecution, what is your response to that?
Your Honor, an excited utterance is given after a specific event occurs, directly after it occurs. This statement was not made directly after something occurred.
If I may respond, Your Honor.
You may.
Your Honor, Jessica Ray had just learned that her son was dead, and Detective Booth told Jessica Ray that. That was the triggering event, and these are the statements that she told Detective Booth in that phone call.
I'm going to agree with defense counsel here. The objection's overruled.
I'm going to ask that question again, Detective Booth. She was, as you just said, she was hysterical. She was crying, sobbing uncontrollably, and she even told you, I knew I should have never left Nathan alone with Timothy when he was acting strange. I knew he was going crazy, right?
She did say that, yes.
Detective Booth, I want to talk a little bit about your background with the police department. You went to the police academy in Skelton, correct?
Yeah, I did.
And you had training on how to interact with individuals that have mental illnesses, did you?
Yeah, we had a little bit of it, yes, sir.
But you don't remember that training, do you?
Not too well, no.
And you work out in the field?
Yes.
So you're working out in the field without remembering this portion of your training?
I have 23 years of experience, so yes, I am qualified to work out in the field, and yes, I do work out in the field.
But that wasn't my question. Detective Booth, I asked you, so you're working out in the field without remembering that particular mental illness training.
aren't you?
Yes.
So you wouldn't know if someone were exhibiting signs of schizophrenia, would you?
Well, no, I'm not a medical expert.
When you had Timothy for the interview, he accused you of being the CIA, didn't he?
Objection, hearsay.
Response?
Your Honor, these are not. This is not for the truth of the matter asserted. Your Honor, this is simply to show the state of mind.
Prosecution, your response to that?
Your Honor, this is being offered for the truth of the matter asserted. It doesn't show state of mind. The defense is offering these statements to show that the defendant said a certain thing to Detective Booth during the interview.
Counsel for the prosecution, is Officer Booth in the CIA?
No.
So then how is the statement being offered for its truth if it is not a true statement?
Because, Your Honor, the way defense counsel is asking this is if the defendant said this statement to Detective Booth during the interview, that is for the truth of the matter asserted.
I'm going to overrule the objection.
Detective Booth, I'm going to ask the question again. You wouldn't know. Well, sorry. When you were interviewing Timothy, he accused you of being the CIA, didn't he?
Yes, he did.
And when you were conducting the interview with him, if he were exhibiting signs of schizophrenia, you wouldn't have been able to tell, would you?
I don't think I'm qualified to make that statement. I'm not sure if I would be able to tell schizophrenic signs. I don't have any medical training in it.
So to clarify, that's a no, Detective Booth.
No, I could assume, but no, I don't know.
No further questions, Your Honor.
Any redirect?
Yes, Your Honor.
Go ahead.
Detective, you were just asked on cross-examination about the defendant's demeanor during your interview with him. At any point during your interview, did the defendant say he didn't understand what you were asking?
No, he said multiple times that he understood everything I was saying.
Did the defendant ever speak incoherently?
No, again, he answered all my questions just fine.
And at any point during that interview, did it look like the defendant was talking to someone else in the room that wasn't you?
No, not at all. I mean, he was talking directly to me every time, kept eye contact when needed. He did well.
Nothing further.
Okay. Prosecution, you can call your second witness.
Your Honor, the people call Dr. McLagreca.
Your Honor, if defense counsel may have a moment to change the room.
Yeah, absolutely, counsel. Take your time.
Defense is ready to proceed, Your Honor.
Good. Go ahead, prosecution.
Good morning. Please introduce yourself to the members of the jury.
Good morning. My name is Dr. Mackenzie LaGreca.
What do you do for a living?
I am a licensed psychiatrist.
How long have you been a licensed psychiatrist?
For 26 years now?
Are there any areas of specialization within your field?
Yes, forensic psychiatry.
And generally, doctor, what does forensic psychiatry entail?
Forensic psychiatry is the application of psychiatry to the field of law. So I consult with attorneys in both criminal and civil matters and provide psychiatric services.
Doctor, how did you become involved in this particular case?
I was asked by the state of West Carolina to review the materials in this case and provide my opinion as to whether the defendant was exhibiting signs of schizophrenia when he killed his son on October 17, 2018.
Were you able to form any opinion on the defendant's mental health?
Yes, I actually formed 2 opinions.
And how much time did you spend, doctor, reviewing the materials and forming your opinions?
25 hours.
Were you paid for your services?
Yes, 500 an hour to review materials and 1750 flat fee to testify at trial.
Doctor, before we get to your opinions, I'd like the members of the jury to get to know you a little bit more. Where did you go to medical school?
I went to medical school at University of Pennsylvania, the Perelman School of Medicine, and then I completed a residency at UCLA in general psychiatry and followed that with a fellowship specifically in forensic psychiatry.
After your education, did you join the workforce?
Yes, I had a practice in New Jersey for 23 years where I worked with patients, including those who suffered from schizophrenia.
Are you board certified?
Yes, I am in 3 states, as well as the American Board of Psychiatry and Neurology, where I am certified in forensic psychiatry.
What does it mean to be board certified?
Being board certified means that you're trained in a specific area of medicine. You have taken the written, or in most cases, an oral exam as well, given by your peers in that specific area to demonstrate your mastery in that field.
Doctor, earlier you mentioned that you reviewed some materials for this case. What materials did you review?
So I reviewed all the materials provided to me by the state, including the defendant's medical history and all the exhibits in the case and the statements of all the witnesses and the diagnostic and statistical manual.
Are these typically the types of materials that experts in your field rely upon?
Yes, they are.
And did you rely upon these materials in forming your opinions and conclusions?
Yes, I did.
And do you hold these opinions to a reasonable degree of medical certainty?
Yes, I do.
And doctor, if there's at any moment throughout this testimony that you're unable to give your opinion to a reasonable degree of medical certainty, will you let us know?
Of course.
Your Honor, at this time, pursuant to Federal Rule of Evidence 702, we offer Dr. Mac LaGreca as an expert in the field of psychiatry with a specialty in forensic psychiatry.
Defense, any objection?
Your Honor, no objections. However, so far, may I take this witness on a voir dire?
No. Any questions that you want to cross her on about her credentials, credibility, whatever, you can cross her on?
Yes, Your Honor.
She'll be kind of expert.
Doctor, at this time, I'd like to focus on the work you did in this case. Okay, earlier you mentioned that you formed opinions. What's your first opinion?
That on October 17th, 2018, the day that the defendant killed Nathan Ray, the defendant did not manifest symptoms sufficiently consistent with a person suffering from schizophrenia.
And what's your second opinion?
That the defendant manifested signs consistent with malingering during his clinical interview with Major Riley on September 8th, 2019.
Doctor, I'd like to start with that second opinion and then work backwards. You mentioned malingering. What is malingering?
Malingering is not actually a diagnosis, but it is pretending to have symptoms of a mental disorder. It can be seen as a form of manipulation, as having an ulterior motive. Although it is often seen in legal cases, it can be used in any situation that a person can benefit from doing so.
Doctor, is it your opinion that the defendant was pretending to have symptoms of a mental disorder?
Yes, on multiple occasions, specifically both during his interactions with the officers and with Major Riley.
What mental disorder was the defendant pretending to have?
Schizophrenia.
Doctor, how can you determine if a patient is malingering?
There are specific factors listed in the Diagnostic and Statistical Manual, also commonly known as the DSM-5.
Do you have any materials that would help you explain these factors to the members of the jury?
Yes, I have a Prezi presentation.
For the record, directing everyone's attention to what's previously been marked as Exhibit 31 for demonstrative purposes. Dr. LaGreca, do you recognize Exhibit 31?
Yes, I do.
What is this?
It's an informative Prezi presentation that breaks down malingering and its factors.
Did you participate in the creation of this Prezi?
I did.
Your Honor, I'm sorry. Is there something being shared on this? Should we all be looking at something?
No, I don't see anything at this point.
Okay, I wasn't sure because of opposing counsel's questions. Okay.
Would this demonstrative help you explain your conclusions to the members of the jury, Doctor?
Yes, it will.
Your Honor, at this time, permission to enter Exhibit 31 into evidence for demonstrative purposes only.
Any objection, counsel?
Not so far, Your Honor, seeing it, but if once we see it, we have any objections, we will urge them at that time.
Have you seen this demonstrative before?
Your Honor, yes, opposing counsel has already.
Prosecution, hold on, counsel. I was asking the defense. I apologize for not making myself clear. Counsel for the defense, have you seen this before?
We clicked through it this morning, Your Honor. I'm pretty much referencing versus the presentation as to what the witness is saying and how the demonstrative plays out. That's what we would object to. As far as how the demonstrative stands right now, we don't have objections.
Okay, obviously haven't. If you have any objections, say so at that time. Prosecution, I apologize for cutting you off, but yes, you may publish it.
All right, Your Honor. Publishing Exhibit 31. Dr. LaGreca, taking a look at Exhibit 31, can you walk us through those factors of malingering you mentioned?
Yes, of course. So first, I consider the legal context of a clinical assessment, which is whether or not the patient in front of me is being prosecuted for a crime. The second factor is if there are any discrepancies between the person's claim disorder and objective findings by a physician.
What type of discrepancies do you typically find when a patient is malingering?
I'm looking for differences between what the person is claiming versus the objective findings of the doctor or those around the patient. So in this case, Major Riley interviewed his supervisor, his ex-wife, and his dad. There was never any mention of them having hallucinations.
Are there any other factors you consider, Doctor?
Yes, there are two additional factors. So the third factor is the failure to cooperate during a diagnostic evaluation. And the fourth factor is whether there's a presence of antisocial personality disorder.
Okay, Doctor, and how many of these factors are required to determine if someone is malingering?
Since malingering is not actually a diagnosis, any combination of these can give you guidance that there may be a case of malingering here.
Okay, Doctor, you mentioned that there were multiple times when the defendant was pretending to have symptoms of schizophrenia. I want to talk about those times. When was the first time that the defendant was pretending to have symptoms of schizophrenia?
The night he was stopped by Officer Wentz at the checkpoint, the defendant changed his behavior when facing legal consequences in this case, the possibility of arrest. For example, when Officer Wentz asked for his license, the defendant started asking about the CIA. Then the officer saw the shovel and the other items in the car, and the defendant began moving slowly or becoming catatonic. Lastly, he had a drastic change of behavior when interviewed by Detective Booth. He was extremely calm in the car ride to the station, but then started crying upon seeing the homicide detectives.
What does this indicate to you?
It indicates to me that he changed his behavior when he was facing legal consequences to a set of very specific behaviors. I'm not surprised by this because he's had a lot of interactions with mental health providers and would know.
Objection, Your Honor.
Recess.
Yes, Your Honor. That type of testimony calls for speculation as to the defendant's motives and his interactions with doctors, and whether he would know by his interactions with doctors how to create symptoms of schizophrenia.
Prosecution, what's your response?
Your Honor, this witness has already testified that everything she is saying today is to a reasonable degree of medical certainty. Your Honor, this isn't just based on the facts of this case. Like, her testimony is also based on her 23 years of experience working with patients, specifically in the field of forensic psychology.
Your Honor, if I may.
Okay.
This witness was called specifically in a murder case to testify regarding the defendant's mental health. Her saying, especially as an expert, Your Honor, her saying that the defendant knows how to fake symptoms of schizophrenia because he's seen a doctor before is highly prejudicial and speculative.
I'm going to sustain the objection. She can talk about her experience and her knowledge of recognizing, whether or not somebody's malingering, but for her to go into the mindset of the defendant I believe is speculation. So I'm going to sustain the objection.
Your Honor, at this time, we'd like to ask for an instruction to disregard the last statements that came from this witness.
That is granted.
Your Honor, we also would ask at this point, we would also ask at this time for a mistrial, Your Honor, because we believe the instruction will not be sufficient for the jury to now weigh the evidence.
That's denied.
Yes, Your Honor.
Counsel for the prosecution, you may proceed.
Doctor, when was the next time that the defendant was malingering?
The next time was after the defendant was arrested for first-degree murder and was interviewed by Major Riley. During his interview, the defendant admitted to hearing voices and not having any intrusive or anxious thoughts in the months leading up to the incident. This, in my opinion, is a very strong sign of malingering because the average person will not be able to distinguish between these two very specific symptoms of schizophrenia and an anxiety disorder.
Okay, doctor, taking a look at all of these factors that we just went through, was the defendant exhibiting any of these factors?
Yes, first, without question, it's clear that the defendant was in the process of being prosecuted for a crime. Second, he gave inconsistent accounts of what happened on that day of the incident, like where it happened, which also indicates that he was malingering. Lastly, he was not cooperative with Major Riley during his interview.
Doctor, did you come to learn what happened in the moments before the defendant killed his son?
Yes, I did.
How did you learn?
I reviewed what the defendant told Major Riley.
Right.
Objection, Your Honor. Hearsay and 704B, Your Honor, we believe that this line of questioning is getting into the statements of the defendant with Dr. Riley, wherein he describes sitting on the bed before going back into Nathan's bedroom, Your Honor. And that goes to the state's burden in today's case as to whether the defendant knew what he was doing and whether those actions were wrongful. Therefore, Your Honor, we object under 704B that, as well as hearsay from the defendant, that these statements not be allowed in today's trial.
What's your response, prosecution?
Your Honor, this witness has been tendered as an expert. Under 703, an expert may disclose anything regarding what they base their opinion on, as long as the probative value substantially outweighs its prejudicial effects. And here, it is probative and necessary for the jury to hear what this expert's opinion is based on in order to properly judge the credibility of that opinion. This substantially weighs any minimal prejudicial effect.
I don't think at this point this is going to the ultimate opinion, so I'm going to overrule the objection.
Yes, Your Honor.
Dr. LaGreca, how did you learn about this?
I've reviewed what the defendant told Major Riley.
Just before killing his son, what did the defendant do?
Objection, Your Honor. Again, to hearsay, if we may hear the statement prior to the jury listening to it, Your Honor, for preserval of error, as well as any other objections as to what we believe opposing counsel is trying to elicit through this witness.
Well, counsel, correct me if I'm wrong, but any statement that the defendant makes is an admission by the party opponent, correct?
Yes, Your Honor. However, in this case, if they're using it to go to the ultimate issue in today's case, it's not allowed, particularly because this is an expert, Your Honor. The federal rules of evidence carry the spirit of inclusion. We agree to that. However, because experts carry a heightened sense of authority and the rules recognize this heightened sense of authority, they are specifically prohibited from testifying as to matters that are reserved for the jury.
I'm going to overrule the objection at this time.
Yes, Your Honor.
Dr. LaGreca, just before killing his son, what did the defendant do?
He sat on his bed and tried to calm himself down, but then ended up getting a belt from his dresser, walking into Nathan's room and strangling his son.
Doctor, was the defendant suffering from schizophrenia on October 17th, 2018?
No, he was not.
Nothing further, Your Honor.
Cross.
Permission to proceed, Your Honor?
You may.
Dr. LaGreca, I'd like to start with talking about schizophrenia. Now, the DSM-5 notes that some symptoms of schizophrenia may be prevalent while others are not.
That is correct.
So it's possible then, doctor, that someone may be 22, have schizophrenia, but not be medically diagnosed until they're 23.
That is correct.
It's also possible then that somebody could be 29, have schizophrenia, but not be medically diagnosed until they're 32.
Yes.
Now, I'd like to talk a little bit about malingering, generally speaking. Now, you testified on direct examination that malingering is pretending to have symptoms of a mental disorder for some perceived benefit.
Yes.
Now, generally speaking, when a person is charged with a crime and describes having a mental illness, they are usually always evaluated to see if they're faking this mental illness, correct?
Of course.
But we can agree that not every person charged with a crime is faking having a mental illness.
Well, when they're being evaluated, it's not just to see that they're faking. They're being evaluated to see if there are any actual substantial symptoms of having a mental illness. And that is usually when someone can see if the person is malingering.
Agreed, doctor, but by that case, when we focus on the end result of the evaluation for malingering, we can agree that not every person who's been charged with a crime who describes having a mental illness is faking this mental illness.
That is correct.
Now, I'd like to talk a little bit about the basis of your opinion today. At this point in time, you've been paid $14,250 by the state, correct?
Correct.
Now, I'd like to start with the symptoms the DSM-5 notes as associated features of schizophrenia. We can agree that childhood trauma is commonly associated with someone developing schizophrenia.
It can be in some cases, but it does not guarantee it.
We can agree that anxiety is an associated feature of schizophrenia.
Anxiety is an associated feature of many things, but it can be included in schizophrenia, yes.
We can also agree that depression is an associated symptom of schizophrenia.
Yes, again, it can be associated with schizophrenia as it is associated with many other things.
Agreed, doctor. But we can also agree that hostility and aggression are associated features of schizophrenia.
Hostility and aggression can come from a lot of different places. They can be seen in schizophrenia, but alone, they are never the only thing that's relied on.
But they are associated with schizophrenia?
Yes.
We can also agree that the DSM-5 notes to look for impairment in someone's interpersonal relations and or self-care.
That is something that you look for, but it is never alone considered for the diagnosis.
Okay, but it is associated with schizophrenia?
Yes.
We can agree that delusions and hallucinations are particularly associated with someone having schizophrenia.
Yes.
Now, I'd like to discuss the reports that you reviewed in today's case. You testified on direct examination that you reviewed all materials, correct?
Correct.
Now, one of the materials that you reviewed was a report indicating Tim experienced childhood trauma.
Based on what his father reported, yes.
Now, you also reviewed reports that Tim was actually diagnosed with general anxiety disorder.
Yes, he was.
You reviewed reports indicating that Tim would be fine one moment and then crying the next.
Yes, that is correct.
You reviewed reports showing Tim was involved in a physical and violent altercation at work.
Yes.
Physical and generally speaking, a physical and violent altercation may be associated with hostile and aggressive behavior.
Yes.
Now, you reviewed reports showing that Tim would lock himself away for hours at a time?
It's unclear what was happening at the time that he was locking himself away, but as a blanket statement, yes, he would lock himself in the room for whatever reason it was.
Well, you also reviewed reports that Tim would go more than a week without showering.
Yes, maybe that was just his preference.
I'm sorry, doctor, you understand you're testifying in a murder trial today, correct?
Yes.
Do you think talking about someone's mental health is funny?
I do not think it's funny at all, but we also need to consider what someone's baseline is. And to say that he did not shower for a week as if it's different from his baseline would be inaccurate because we do not have any information about his baseline.
To clarify, this information, particularly regarding Tim's interpersonal relations, came from his wife, correct?
Correct.
To further clarify, did you go talk to Jessica Ray?
No, I did not. The notes that were provided based on her interview were sufficient.
Okay, so we can agree to go back a little bit and say that you reviewed reports that Tim was locking himself away for hours at a time.
That is what she said.
You reviewed reports showing that Tim would go more than a week without showering.
Again, that is what she said in the one interview. Yes.
You reviewed reports indicating that Tim was always struggling with mood swings.
Yes.
You reviewed reports that Tim became a completely different person prior to his wife leaving him.
Going through a divorce and a separation, as I'm sure you know, is a very serious matter and can really affect someone. So the fact that he turned into a different person, as you say, I am not surprised by this at all.
I completely agree, doctor, and I have the utmost sincere respect and appreciation and empathy for people who go through divorces. Absolutely, I'm with you there. However, to clarify for the jury and for the court, this statement was made by Jessica Ray when she was informing Dr. Riley that Tim became a completely different person even prior to her leaving him. So to further clarify, Tim at this point did not know he and his wife would be separating, correct?
Was that before or after he found out that she was cheating on him?
Before. You reviewed the report, doctor. Are you unsure?
No, that is correct. But he was having moments where he thought that she was cheating on him. And again, that is a very stressful thing for him to go through.
I understand, but that was not my question. So to clarify, before Tim knew his wife was cheating and before she had informed him that she would be leaving, she reported that he had turned into a completely different person.
Yes, that is what she reported.
Now, you also reviewed reports showing that Tim was seeing things that nobody else could see and hearing things that nobody else could hear.
Based on what he reported, that is what it said. Yes.
You also reviewed reports indicating that, you also reviewed reports indicating that Tim believed people were listening in on his conversations.
Yes, I believe that was after he was arrested.
Oh, let's clarify. You testified you reviewed all the reports in today's case.
Yes. That
includes Dr. DiGiuseppe's testimony?
Yes.
And in Dr. DiGiuseppe's testimony, she identifies a 2016-2017 appointment, correct?
Yes.
And in this appointment, she states that Tim accused her of listening in on his phone calls.
Yes.
Dr. LaGreca, do you have a reason to believe that Dr. DiGiuseppe was listening in on Tim's phone calls?
I'm pretty sure, if I'm incorrect, please let me know, but I'm pretty sure he said that after she questioned him about wanting to hurt his wife or son.
That's not what I asked. Did she or did she not identify the fact that Tim accused her of listening in on his phone calls?
She did.
I would now like to instruct my tech advocate that he may bring the demonstrative down from the screen. Now, to further clarify the evidence in today's case, Dr. LaGreca, we can agree that most of those reports identified observations and behaviors of Tim from his early 20s to about his early 30s.
Yes.
We can also agree that the DSM-5 notes that schizophrenia may develop anywhere between someone's mid-teens all the way to their mid-30s, correct?
That is correct.
So to further clarify, doctor, these observations and symptoms and behaviors of Tim fall within the age range in which someone may develop schizophrenia.
Yes.
No further questions at this time, Your Honor.
Any redirect?
Just a few, Your Honor. Doctor, you were asked about the defendant's interactions with his primary care physician, Dr. D. Giuseppe. Did the defendant ever report to Dr. D. Giuseppe he was experiencing hallucinations?
No, he did not. In
Did
fact, he did.
Oh, sorry. Go ahead, doctor.
And he did not report many of the symptoms that are associated with schizophrenia at that time.
Right. Did he ever report delusions?
No, he did not.
What about voices, doctor? Did he report that?
No, he definitely didn't.
Nothing further, Your Honor.
Okay, the witness is excused. Prosecution, do you have any more witnesses?
No, Your Honor, at this point, the state rests.
Okay, would the parties like a brief recess at this point?
Yes, Your Honor, and a time check too.
Okay, make sure that you confer with the time checkers on your own, and then let's take, we can take let's take 6 minutes. So just turned 11:34. Everyone be back at 11:40.
Your Honor, to clarify, the defense does have a mid-trial motion. Would you like to hear that once we come back?
Respectfully, counsel, that motion will be denied.
Okay.
All
No
right.
problem.
11:40, everybody. All right, is everybody ready to go?
Your Honor, I just want to quickly confer with the defense's timekeeper and then.
Yeah.
Thank you.
All right, is everybody ready to go now? You conferred with the timekeepers. Everybody ready to go?
I haven't heard from the time. I don't think any of us have heard from the timekeepers yet.
All right, I believe the timekeepers are your teammates, right?
Yeah, I think they're talking right now to each other.
All right. Let me know as soon as they're done so we can get rolling.
Your Honor, Your Honor, this is the timekeeper for the defense. We've conferred with the timekeeper for prosecution. We've come to an agreement on the times.
Okay.
I think both parties know, but I'll state it for the record. The state has 23 minutes and 37 seconds left, and the defense has 30 minutes and 13 seconds left.
Okay. Defense, call your first witness. You are muted, counsel, for the defense, just so you know.
We call Officer Wentz to the stand.
Okay, go ahead.
Good morning, Officer Wentz. Can you please introduce yourself to the court?
Yes, hi, my name is Officer Peyton Wentz of the Skelton Police Department.
What type of training did you receive in order to become a part of the Skelton Police Department?
Sure. At the academy, I received training in police procedure, investigatory tactics, how to conduct a traffic stop, as well as a special program on mental health type issues and how to recognize them and how to de-escalate situations that occur with people who are experiencing psychosis or schizophrenia.
How long have you been an officer for the Skelton Police Department?
It's going to be about 4 years now.
Officer Wentz, I'd now like to talk a little bit about how you know the defendant. When did you first interact with the defendant?
Yeah, well, he pulled up to the routine sobriety checkpoint on the outskirts of downtown Skelton. And I walked over to his car and I asked him to roll down the window, but, I could tell something was off.
Well, before we get to that, Officer Wentz, in your time working the sobriety checkpoint, have you interacted with drivers who appeared to be angry?
Yes.
Have you interacted with drivers who appear to be sad?
Yes.
Have you interacted with drivers who appear to be under the influence?
Yes.
How did the defendant, Timothy Ray, appear to you when you first interacted with him?
Well, he looked disheveled. His eyes were blurry. I was confronted with an overwhelming body odor coming from the defendant. His clothes were a mess, and the car looked like it had been slept in for days.
How did you continue to interact with the defendant after noticing those things?
Well, everything, he was arguing with me during our interaction, but, eventually he gave me his identification. He seemed to be understanding my questions, but I was suspicious.
Why were you suspicious?
Well, I was suspicious because he wasn't slurring his words. There was no slurred speech, but he just seemed odd.
Well, why do you say odd?
Well, I gave his identification to my partner, but I stayed by the car, and that's when things went from odd to him asking me crazy questions.
Your Honor,
Objection, Your Honor.
Basis?
We'd like to re-raise our motion in limine. Oh, sorry, basis. For improper lay testimony, Your Honor.
I'm going to grant this objection for this. Typically I understand counsel for the defense that, in a typical case or a case not involving your defense, someone describing something as crazy might be okay, but isn't that essentially a synonym for your defense right now?
While it's a synonym, Your Honor, because it's coming from this witness is not qualified as to actually testify to the defendant's personal mental state. This witness is merely testifying as to what he perceived and his interactions with the defendant on that night, Your Honor.
But for him to qualify those actions as crazy, I think is not allowed. So I'm going to sustain the objection. He can talk about what he saw and what he heard, the five senses, but for him to then take the extra step and qualify it as something, I'm not going to allow that.
Yes, Your Honor. To clarify, may I still ask what this question was without qualifying it as crazy?
Yeah, of course. You can still rephrase the question. Absolutely.
And one more thing, Your Honor.
Of
May
course.
I constructively instruct my witness to refrain from using the word crazy?
Yes, you may.
Okay. Officer Wentz, did you hear that?
Yes.
Okay. Officer Wentz, what question did the defendant ask you?
He asked me if I was with the CIA.
Objection, hearsay.
Your Honor, we're not offering it for the truth of the matter asserted. It goes to the defendant's mental state.
I'm going to overrule the objection.
I'll re-ask that one more time, Officer Wentz. What was the question the defendant asked you?
He asked me, "Are you with the CIA?"
How did you respond to that question, Officer Wentz?
Well, I pointed at my Skelton Police Department badge and I said, I'm a police officer. I'm conducting a routine traffic stop. But then he kept on saying things. He asked, are you sure you're not with the CIA? He began to say, I know they're after me. They thought he was, they think I'm a terrorist. It was very odd to me. And I just kept on telling him I'm a Skelton police officer.
Officer Wentz, where was this behavior, or where was the defendant when he was asking these questions?
He was still in the car. His window was open. He was communicating these questions to me through the open window. But after he said all these questions, then I asked him to get out of the car.
So from inside the car to now outside the car, what was the defendant's behavior like?
Well, when he opened the door and he got out of the car, it seemed like he was moving in slow motion, like a zombie or something. And he was, muttering to himself quietly. and he just kept on moving very oddly, which this contrasted what was happening inside the car because, he was asking me these frantic questions, and now, he was like a zombie.
Officer Wentz, how did you continue to interact with the defendant after noticing this behavioral change?
I just kind of was trying to talk to him, but it didn't seem like he was hearing me, or if he was hearing me, he was ignoring me, because he then started to do a jumping jack.
What happened, or how did you react to the defendant doing a jumping jack?
Well, I told him to stop doing a jumping jack, and then he did another one. And, at that point, I told him to stop again, and then I pulled out my gun.
How did the defendant respond to you pulling out your gun?
Well, he stopped doing jumping jacks, but then he put his hands over his ears, and he began to move his head around uncontrollably, like a kid who's trying to avoid hearing something. And at that point, I handcuffed him. I was able to restrain him and put handcuffs on him and take him to the ground.
At this point, Officer Wentz, did you know the defendant was a suspect in a missing persons report?
No, I did not know that at the time. I was later informed of that by my partner, who was running Timothy Ray's identification.
No further questions at this time, Your Honor.
Okay, cross-examination.
Yes, Your Honor. Officer Wentz, you just testified that you've been on the police force for 4 years, correct?
Well, 4 years now.
Right. But at the time of the arrest, officer, you had only been on the force for 2 years. Isn't that right?
Yes.
About 2 years. You are a rookie, Officer Wentz. Isn't that right?
Yes, I was.
You typically work traffic stops.
Yes, that was kind of my beat. Yeah, that's what I was assigned to, yes.
Right. An exciting night for you is a couple of DUI arrests.
Yes.
You've never investigated a murder.
No.
You don't hold a single degree in psychology.
No, I don't.
You've never even encountered a mentally ill suspect. Isn't that right?
Not that I can recall.
Yeah. Let's talk about your work here in this case. The defendant stopped at your sobriety checkpoint on October 19th, 2018.
Yes.
You approached his window and you asked for his license.
Yes.
He wouldn't give it to you.
No, not at first.
He said he left it at home.
Right, but then I pointed out, I could see your wallet, and then he eventually gave it to me.
Right, but he lied to you. Isn't that right?
Yeah.
He finally turned over his license.
Yes.
And as you were on your way back to your squad car with the defendant's license, something caught your eye in the defendant's back seat.
I noticed several items in his back seat, yes.
Yeah, one of those items was a dirty shovel.
Yeah.
The dirty shovel looked like it had blood on it.
Yes.
You saw 2 jugs of bleach.
Yes.
Officer, you also saw large black trash bags. Isn't that right?
All of that was right there in the open.
Yeah. At that point, you knew you couldn't walk away from the defendant.
Well, I didn't want to leave him, but I did have to give his information to my partner. So that's why I did that, so I could stay close to him.
Right, officer, you gave your partner his license so that you could keep an eye on the defendant.
That's correct.
You were afraid that if you left, he'd drive off.
That was a possibility that had crossed my mind, yes.
And, officer, after you noticed these items in the defendant's back seat, his behavior changed, didn't it?
Yeah, he started asking me those crazy questions.
Right, suddenly, the defendant no longer knew who you were.
Yeah, I guess so.
Yeah, and at this point, though, you had already identified yourself as a Skelton police officer. Isn't that right?
Yeah. If I didn't say that orally, it was pretty clear by my uniform and, kind of that we were at a checkpoint. That's who I was.
That's a yes, Officer Wentz, correct?
Yes.
After you saw the dirty shovel, the defendant starts asking you if you're a member of the CIA.
Yes, that was the order of events.
He didn't accuse you of being a part of the CIA when you first approached his vehicle.
No.
Or when you asked for his license.
Nope.
Now, let's talk about when the defendant got out of his car. His behavior changed. Again, isn't that right?
Yes.
he started moving slower.
Yes.
He had a blank stare on his face.
Yes.
He couldn't even look you in the eyes. Isn't that right?
Yeah, it was just, I've never seen anything like that.
Yeah. And he said, I didn't mean it. Isn't that right?
Yeah, I believe he said something like that.
So that's a yes, Officer Wentz. He said that.
Yes.
But that's not the only thing he said to you.
Yeah, he said a lot of things. Yes.
One of those things was, I messed up. Isn't that right?
I believe so.
Now, eventually you drove the defendant to the police station. Let's talk about that ride. Once again, the defendant's behavior changed. Isn't that right?
Yeah, I think he was crying.
Well, he became calmer. Officer Wentz, he wasn't crying, he became calm.
Objection, Your Honor. Counsel's testifying.
Officer Wentz, the defendant became calmer once he got into the car. Isn't that right?
I believe so. I believe he was calm in the car.
Is that a yes, Officer Wentz?
Yes.
And he remained calm until he was placed into the interview room. Isn't that right?
Yes, I think he started crying in the interview room.
Right. Officer Wentz, he remained calm until he got into the interview room. Isn't that right?
Well, I think he was talking to himself in the backseat of the car.
Officer Wentz, that wasn't my question. He remained calm until he was placed into the interview room. Isn't that right?
I'm not sure what your definition of calm is.
Well, Officer Wentz, is it your testimony that the defendant didn't remain calm until he was placed into the interview room?
Objection, Your Honor. Counsel is misstating the witness's words.
Objection. She's asking a question.
Yes, Your Honor.
Officer Wentz, directing you back to my question, the defendant remained calm until he was placed into an interview room.
Yes.
And when Detective Booth, the homicide detective, walked into that interview room, the defendant became a totally different person. Isn't that right?
He started crying.
Officer Wentz, that wasn't my question. Redirecting you back to my question, when the homicide detective walked into the interview room, the defendant became a totally different person.
Yes, because he started crying.
Nothing further, Your Honor.
Redirect.
Yes, Your Honor. Officer Wentz, how was this interaction different from any of your other interactions with other drivers?
Well, this interaction was unlike anything I'd seen before.
Did you know the defendant prior to this traffic stop?
No, I did not.
No further questions, Your Honor.
Okay, defense, call your next witness, please.
Your Honor, if I'm 10 seconds to switch with my co-counsel.
Yes, and whenever he comes back, just let him go right into it. That's fine.
Got it, Your Honor.
Your Honor, at this time, defense calls Dr. Shane Riley to the stand. Could you please introduce yourself to the members of the jury?
Sure. Hello, my name is Dr. Shane Riley.
Dr. Riley, what do you do for a living?
So I am a licensed psychiatrist and I own and operate Riley Forensic Psychiatry.
Well, you mentioned Riley Forensic Psychiatry. What is that?
So forensic psychiatry is a specific subset of psychiatry. It specifically looks at the intersection between our legal system and psychiatric conditions.
And what did you do before running Riley Forensic Psychiatry?
Right. So I was I was in the military and I worked at Walter Reed, and I worked as a psychiatrist for almost 20 years.
Were you licensed by any boards in order to practice psychiatry?
Right. So similar to the other expert witness here, I was licensed by the American Board of Psychiatry and Neurology.
After practicing psychiatry for a number of years, have you worked with a lot of mental illnesses like schizophrenia?
I have. So I've seen a large volume of patients over my time as a psychiatrist, and with schizophrenia specifically, I've actually published twice now on schizophrenia.
Have you ever served as an expert witness before, Dr. Riley?
Yes, I have. In 25 trials, 18 of which were criminal trials.
So when you testified, was that only for the defense or have you testified for the prosecution as well?
I have testified on both sides.
What did you do in preparation for today's trial?
So for today's trial, I did review the entirety of the record. I also reviewed and contributed my own interactions with him as my patient, both in 2010 and 2019, and conducted several interviews with people that were close to him to provide context.
Is that a reliable practice in your field to do all those interviews and take the path that you did?
Right. So having been a psychiatrist back in 2010 and having been brought onto this case in 2019, with that 9-year gap between the last time that I saw him, this was me doing due diligence to understand really where his symptoms were presenting during those 9 years.
And is that method a reliable approach?
Yes. So I used what I discovered in comparison with the DSM, which is a standard method in psychiatry.
All right, well, let's talk about the DSM a little bit more. What is that?
So the DSM is the Diagnostic and Statistical Manual, as the other expert witness referenced. This is something used in psychiatry to diagnose mental illness.
And is that a reliable principle in your field?
It is.
What did you do with the DSM in this case?
So in this case, I looked at the presentation of his symptoms and correlated them with the DSM to make sure that I was making the proper diagnosis, of which I diagnosed him with schizophrenia.
Is that a reliable method in forensic psychiatry?
Yes, this is relied upon by psychiatrists in making a diagnosis.
Dr. Riley, do you think that your testimony will be helpful in assisting the jury in understanding this case?
I do. This case concerns the mental health of Timothy Ray, of which I have been a psychiatrist for him and witnessed firsthand. Also, my knowledge and experience in forensic psychiatry, I believe, will help with the legal context of this trial.
Your Honor, at this time, defense tenders Dr. Shane Riley as an expert in forensic psychiatry.
Any objection?
No objection, Your Honor.
All right, go ahead, Councilman Lieutenant.
Dr. Riley, I want to talk a little bit about you and Timothy in this case. How do you know Timothy?
Right, so back in 2010, I was working with the Army. Timothy at that time was active military personnel, and he was referred to me for having experienced sleeping difficulties and seeing things.
How long was it reported that he was seeing things?
So this was reported by his senior officer, and I believe it was for. I would have to see his testimony, but I believe it was for around a month.
Okay, no worries, Dr. Riley. Doctor, what happened in that interview in 2010?
Right, so in 2010, he came to me. He was complaining of depression, anxiety, significant stress, and after conducting this interview, I did diagnose him with generalized anxiety disorder and suggested that he see a psychiatrist for follow-up.
Was that the only time that you saw Timothy Ray?
No, so I did see him again in 2019. This is when I had a clinical interview with him, which I used to make my diagnosis of schizophrenia.
Well, let's talk about that more. What did y'all talk about in that clinical interview?
Right. So we met for several hours in which he described the symptoms that he experienced on the day of the incident, as well as symptoms that he experienced over the course of his life.
What was so remarkable about those time periods?
So I wanted to have an understanding for what he has been experiencing over his life prior to the incident, and then also just leading up to the day of the incident, what he was experiencing. This is a holistic approach that I used.
Let's talk about all that. First, I want to talk about the things y'all discussed when he was young. Tell the jury about that.
Right. So he explained that he started hearing these voices when he was 10 years old. He didn't tell anyone or seek treatment because I believe his mother had also been diagnosed with a mental illness and he didn't want to be seen similarly.
Well, all right. Well, what about the symptoms leading up to the day of the incident?
Right. So leading up to the day of the incident, he did comment that these voices had started returning. He did specify that these were male voices, not intrusive thoughts, and that these voices were telling him to do things, which as a psychiatrist, we would classify as a command hallucination, which is highly concerning.
Well, let's talk about that. What is command hallucinations?
So command hallucinations are when someone experiences a voice or an auditory hallucination that is telling them something or telling them to do something, i.e. a command. These are concerning for many reasons, but any psychiatrist would be on high alert for these.
I want to talk, what did y'all talk about on the day of the incident?
Right. So on the day of the incident, he reported that the voices had returned. He said that Timothy, that he was with his son in the morning, that his son had spilled juice on his computer, and these voices claimed that this was an act of sabotage.
Okay, the voices told him it was an act of sabotage, and then what happened?
Right. So he said that he forced Nathan to exercise as punishment, but this, in his words, creepy voice, kept telling him that he needed to strangle and kill his son. So he did.
Dr. Riley, how did Timothy act in the duration of the 2019 interview?
Right. So Timothy acted a little strange. During the interview, about halfway through, he started sweating profusely and showing signs of paranoia. He did accuse me of being a government agent who was out to get him. And he did become upset at one point that there was a camera in my microwave. And he also made an odd statement when I questioned him.
Okay, well, we'll break that down. But before we get to the odd statement, was there a camera in your microwave?
No, there was not.
Dr. Riley, well, let's talk about that odd statement now. What was that odd statement?
Right. So in order to kind of ascertain the severity of his delusions, I did ask him whether or not he would have committed the same act if there were policemen in the room, to which he did answer yes.
I want to talk a little bit more about that accusation against you. Was that the only time that Timothy has accused someone of being in the CIA, based on your review of the record?
Per my review of the record, that would not be the only time.
Well, when were the other times?
So on my review of the record, he accused me, Detective Booth, and Officer Wentz.
And all those took place after the incident occurred, right?
Right. Those were all after the incident occurred. There was an instance in my review of the record that could classify as a delusion prior to this incident, however.
Well, let's talk about that. Can you explain that to the jury?
Sure. So in my review of the record, the only other medical professional that has seen him, his PCP, Dr. Giuseppe, had reported that Timothy did not look okay to her and had even accused her of listening in on his phone calls.
How does that fall into this, your report?
Right. So this would have been an incident that was prior to this. This incident was prior to the incident of him killing his son. And so this would have been an example or pointing more towards the timeline of his symptoms. Additionally, this concept of someone listening on his phone calls is something that is consistent with his viewpoint of accusing people of the CIA. So it is a consistent delusion.
Dr. Riley, you were here when Dr. LaGreca was testifying, right?
I was.
And did you understand everything that she was saying?
I did. I respect her opinion.
And you saw the demonstrative that my co-counsel worked with Dr. LaGreca, did you?
I did.
Talking about it, do you believe that if we continue to talk about it, that would assist the jury in understanding how schizophrenia works in your report?
Right. I think using this demonstrative could really help the jury understand how I considered all the symptoms and in their entirety.
All right, let's talk about it. So on the screen right now, as you can tell, we have these symptoms and features, and we asked Dr. LaGreca where, if it was present in the record. So I want to ask you that as well. I want to create a third column, and I want to highlight for the jury where was it exhibited.
Sure.
Can you do that?
Yes, I can.
All right. How does childhood trauma factor into schizophrenia?
So as pointed out previously, schizophrenia is a multifactorial disease, which means there are many things that can contribute towards the development of schizophrenia. Childhood trauma is one of these.
And was that present in the record?
Yes, it was.
Where was that exhibited?
So this was exhibited through my conversation with his father during an interview that I conducted afterwards to ascertain a childhood context for the disease. His father did comment about how his mother was neglectful and his mother ended up being institutionalized. And this neglectful behavior could classify as childhood trauma.
Let's talk next about anxiety. How does anxiety fit into schizophrenia?
So anxiety is a known associated symptom of schizophrenia. It is something that could be present in anyone that has schizophrenia.
Was it present in the record?
It was.
And where was that at?
So this was something that I myself diagnosed back in 2010. I had diagnosed him with anxiety disorder, and throughout the 9 years, he had reports of anxious thoughts.
How does hostility fit into schizophrenia?
This would be another associated symptom of schizophrenia. Hostility or aggression could be a presentation.
Where was that exhibited?
So this was in the record, and it was exhibited in an interaction at his workplace, which I ascertained through conversations with his boss.
What about impairment? How does that fit into schizophrenia?
Right. So for any medical or mental illness, you do have to understand whether or not these symptoms are causing an impairment in their daily life, whether that is their ability to care for themselves or their social interactions. And with schizophrenia specifically, this is something that we would be looking for.
And where was that exhibited?
So this was in the record, and this was exhibited both with his own personal hygiene. This was something that was commented by multiple people in the record, that he was unkempt, or that per his wife, that he would go weeks without, or lock himself up for weeks or weeks without bathing.
Let's talk about delusions and hallucinations. How do those fit into schizophrenia?
Right, so this would be what is called a positive symptom. So this is something that schizophrenia and is very familiar with schizophrenia. And this is a presentation where someone experiences delusions or hallucinations, and this is a common aspect of the disease.
And was that present in the record?
Yes, it was.
Where?
So this was present both in interactions with myself and authority figures like the police. This was also present in the past with interactions with Dr. Giuseppe.
At the end of the 2019 interview, did you have to make an expert diagnosis?
I did.
And what was that?
So I had, based on the presentation and the consideration of all these symptoms, these are not just isolated incidences. These are things that you have to consider in their entirety and collaboratively. So looking at the presentation or the factors that factored into his childhood, including symptoms that he presented with up until this unfortunate incident, it is apparent to me that he was suffering from severe schizophrenia.
Going back to your opinion, what were your expert opinions in this case?
Right, so I made two opinions in this case. One would be that Timothy, unfortunately, was suffering from severe schizophrenia on the day of the incident. And the other would be that the severity of his schizophrenia would have caused him to become temporarily insane the day of the incident.
No further questions at this time, Your Honor.
Cross.
May I proceed?
You may.
Major Riley, on cross-examination, you testified that the defendant's mother was diagnosed with a mental illness, correct?
Yes.
Isn't it true that the defendant's mother was never diagnosed with a mental illness?
Okay, so she was institutionalized, which would indicate that she was suffering from a mental illness. So I apologize if I specifically said that she was diagnosed.
Riley, is that a yes? The defendant's mother was never diagnosed with a mental illness?
To my knowledge, no.
In fact, you never interviewed the defendant's mother, did you?
No, I interviewed the father. I was unable to get in contact with the mother.
Never even sought the mother's medical records?
No.
And the defendant's father was never diagnosed with a mental illness either, true?
I was working in the context of childhood trauma, not from whether or not the father had mental illness. So no, the father was not diagnosed with mental illness in the past.
Major, you typically charge $450 an hour to review materials.
Objection, Your Honor.
Basis.
Your Honor, on relevance first.
Okay, I'm going to overrule the relevance objection. What's the next objection?
The second is outside the scope of the direct, Your Honor. We never once spoke about payment.
I'm going to overrule that objection as well.
Yes, Your Honor.
Major, you typically charge $450 an hour to review materials, correct?
Like the other witness in this trial, I do charge for my time, yes.
But today, you cut a deal with the defendant.
As someone who is a member of the military and recognizing this is also another member of the military that has to go through the military system, I felt it was my responsibility to cut a deal, yes.
Major, you're charging him a cheaper rate for your testimony, right?
I think the rate is still fair, but it is cheaper than my usual rate, yes.
And Major, you and the defendant have a history, isn't that true?
I have seen him once in a 2010 interview by which I diagnosed him, yes.
And you want to ensure a favorable outcome in this case, correct?
If you're referring to the fact that this witness or this defendant has schizophrenia, and I am hoping that people can understand that he has schizophrenia, then yes, that would be considered favorable in my opinion.
Now, Major, you concluded that on October 17, 2018, the defendant was experiencing symptoms of schizophrenia, correct?
Yes, based on his reports.
And one of those symptoms you concluded that he was experiencing was auditory hallucinations.
Yes.
But Major, you would agree before being arrested, the defendant never reported to anybody that he had been hearing voices.
He did not report hearing voices, but there was at least an instance of delusions.
Major, that wasn't my question. In fact, the defendant didn't report any hallucinations or delusions until after he was questioned by Detective Booth.
As he indicated in my interview with him, he did not report auditory hallucinations, but he also was working under a worry of being perceived similar to his mother, yes.
Major, I'm asking simple questions. The defendant didn't report any hallucinations or delusions until after he was questioned by Detective Booth.
Sure.
Now, you also relied on an interview given by the defendant's employer, Nia Jacobs.
I did.
Ms. Jacobs told you the defendant was a fantastic employee for 8 years.
She did.
Major, isn't it true that it's atypical for a schizophrenic person to maintain steady employment for 8 years?
It would be typically, but if it was prior to his symptom onset, sure.
And Major, in your report, you didn't state that this was a rare case, did you?
I don't believe I did.
No, Major, you diagnosed the defendant with anxiety disorder and depression in 2010.
I did. As someone coming from the military, I recognized those symptoms and I diagnosed them and gave him proper treatment and asked him to seek follow-up treatment at that point.
Right, Major. You didn't diagnose him with schizophrenia.
At that point in time, if I wasn't receiving reports of delusions, which weren't present at that time, then no, I diagnosed him with anxiety disorder, which was appropriate.
Major, again, I'm asking very simple questions. You did not diagnose him with schizophrenia in 2010, did you?
No, I did not.
In fact, the defendant outright denied experiencing hallucinations in 2010.
Yes, per the report.
He denied experiencing delusions.
In 2010, yes.
Now, you also told this jury today that the defendant was not malingering on September 8, 2019.
Right. I wrote in my report that I had considered this as an option and dismissed it because there was a more reasonable or a better explanation for his symptoms.
Truth is, Major, you can't say with certainty whether or not the defendant was faking symptoms of schizophrenia.
I can say based on his presentation that his symptoms fit schizophrenia.
Major, my question was, you cannot say with certainty the defendant was not malingering, isn't that right?
I'm confused with what you're trying to say here.
Well, Major, those are your own words, isn't it? You can't say with certainty the defendant was not malingering.
I mean, in any case, you can't say with certainty, but you can look at the record to see what is the most reasonable conclusion.
Now, the defendant also told you what happened on October 17, 2018.
Yes.
But his story was off on several key facts, correct?
I recall one key fact, but sure.
Well, Major, let's go over it. First, he told you that Nathan picked up and smashed his laptop.
He did.
Then later, he told you that wasn't true.
Right. I commented on this inconsistency in my report. If he was experiencing severe hallucinations at the time, it's not unreasonable that this would be a discrepancy.
Major, you also know that he told Detective Booth that he strangled Nathan in Nathan's bedroom.
I do recall reading that.
But to you, he again said something different.
I will cite what I said previously, that someone who is experiencing severe schizophrenia may have mistaken their memory.
Major, he told you that he strangled Nathan in the kitchen.
Yes.
And you would agree that inconsistencies in a person's story is a sign of malingering, correct?
Yes, it would have been.
And when you confronted the defendant with these inconsistencies, he shut down.
Yes.
Major, he became angry when you confronted him with his story.
That was the timeline, yes.
And Major, you would agree that a lack of cooperation during a diagnostic evaluation is a sign of malingering, correct?
It could be.
Nothing further.
Brief redirect, Your Honor. Dr. Riley, did you know as much as you do now about Timothy's mental health back when you first saw him in 2010?
I did not. 2010 was the first time that I had seen him as his psychiatrist, and I gave him appropriate care. And in reviewing the record and with my meeting of him in 2019, I did my due diligence when I was reviewing then.
No further questions, Your Honor. Ask that the witness be excused.
Let's take 2 minutes as a break, and then we'll get to closings. All right, is everybody back?
Your Honor, I have just conferred with the other timekeeper for the state, and I just wanted to announce what the time for each party has left.
Yeah, go ahead.
So the state, they have 10 minutes left to close, and the defense has 8 minutes left to close.
Okay. So we will now hear closing arguments from each party. Everyone should please switch back to speaker view so that we can see the one person who is speaking. I'll give everybody a moment to do that. And prosecution, whenever you are ready.
May it please the court, counsel, ladies and gentlemen of the jury. Nathan Ray was a 6-year-old boy full of life. He loved playing soccer, going to school, and just living life as any 6-year-old should. But Nathan's life was cut short, taken away by his own father, the defendant. The last thing 6-year-old Nathan saw while he was alive was his dad, the person he's supposed to trust the most, standing over him, squeezing and tightening a belt around his neck, pulling until Nathan stopped crying, stopped screaming, stopped moving. Members of the jury, you've been brought here today to bring Nathan the justice he deserves, to hold the defendant accountable for killing a boy who had no fighting chance against a man. Ladies and gentlemen, when these arguments conclude, His Honor will instruct you on the law. And he will tell you that today we had the burden to prove to you, beyond a reasonable doubt, that the defendant caused the death of Nathan Ray with malice of forethought. Now, ladies and gentlemen, malice of forethought. All that means is that we have to prove the defendant killed another person willfully, intentionally, or deliberately. And make no mistake, ladies and gentlemen, the defendant intended to kill his son. Let's take one last look at the evidence. Today, you heard from the lead detective on Nathan's case, Detective Booth, and he took this stand and told you the defendant confessed to killing his son. And members of the jury, we now know how. 6-year-old Nathan was put through a rigorous military-style punishment. He became exhausted. He couldn't keep up. But the defendant wouldn't just let it end there. No, instead the defendant sat on his bed and thought about what to do next. Then he grabbed a belt, tied it around Nathan's neck, and pulled until there wasn't a single last breath to pull out of Nathan's body. Ladies and gentlemen, you know the defendant didn't just stop after he killed little Nathan. You heard how he tried to cover up his crime. You saw what the defendant searched on Google the day after he killed his son.
Objection, Your Honor, misstatement of the facts.
Overruled.
Yes, Your Honor.
Countries that don't extradite for murder charges. How to get rid of a body. Will bleach destroy a body? Then, the defendant drove to a secluded area, stuffed Nathan's body in a garbage bag, throwing Nathan's body out like a piece of trash, trying to hide and bury the heinous crime he committed. Members of the jury, we know the defendant didn't just confess to Detective Booth. He confessed to Officer Wentz, the defendant's own witness too. He said, "I messed up. I didn't mean to." Now, speaking of Officer Wentz, the defense wants you to believe that what Officer Wentz saw were the actions of an insane person. But members of the jury, we were all here today. We heard when Officer Wentz was questioned. He may have seen the defendant acting strangely, But what's important is when the defendant was acting strangely. Today, you heard Officer Wentz testify that when he first approached the defendant in his car, the defendant lied to him, told Officer Wentz he didn't have his ID, even though it was sitting right next to him. Only when the defendant was forced to identify himself, only when Officer Wentz saw the shovel, trash bags, and bleach, the defendant changed his demeanor again. All of a sudden now, he's asking about the CIA. And when the homicide detective walked in, well, the defendant became a totally different person. Ladies and gentlemen, these are not the actions of a mentally insane person. These are the actions of a cold-blooded killer, desperate to try and save himself and cover up the crimes he committed. Members of the jury, we now know the defendant killed his son. We know he sat on his bed. We know he had time, had all the time in the world to make the right decision. But he didn't. The defendant strangled his son on October 17th, 2018. Now, keep in mind the timeline of the defendant's strange behavior, the behavior that the defense wants you to look so closely at. This strange behavior only began after the evidence started to build against him. Now, I expect the defense will try to convince you that the defendant is insane, but remember what you heard here. Keep in mind the timeline of these symptoms. You heard from Dr. Mac LaGreca, an expert in forensic psychiatry. And today she took this stand and told you that the defendant never exhibited symptoms of schizophrenia. In fact, the defendant was malingering, faking symptoms of a mental illness in order to avoid the consequences for killing his son. Now, what does that mean, ladies and gentlemen? It means the defendant's symptoms of schizophrenia were just made up. No doctor prior to Major Riley, who, by the way, is being paid by the defendant, has ever diagnosed the defendant with schizophrenia. And because Major Riley was the only one to testify today that the defendant is schizophrenic, we have to ask ourselves, why? Well, after today, you now know it's because now a child is dead. It's of no surprise that now the major wants to tell you her patient is insane. And that, oh yeah, she saw symptoms back in 2010 too. But members of the jury, she didn't see any schizophrenic symptoms in 2010. She told you today that the defendant denied hallucinations, that he denied delusions. Major Riley is talking out of both sides of her mouth, just like the defendant. Don't fall for it, members of the jury. The defendant knew exactly what he was doing when he tied a belt around Nathan's little neck and squeezed until Nathan took his last breath. The defendant knew what he was doing when he searched for how to get rid of a body.
Objection, Your Honor, misstatement of the facts. Yes, Your Honor.
The defendant knew what he was doing when he stuffed Nathan's body in a garbage bag and threw him out like trash. Nathan was powerless against the defendant. But now you have the power to do what's right, to tell Nathan that his life was worth more, to hold the defendant accountable for killing his son. Return with the only verdict that is consistent with the law and supported by the evidence. Find the defendant guilty.
Your Honor, may I instruct my tech advocate to go ahead and pop in when I have 1 minute left, if that's okay?
Yeah, whatever you gotta do.
Okay. May it please the court, opposing counsel, members of the jury. Undiagnosed and untreated is what led to the unexpected tragedy in today's case. It's how schizophrenia was able to take 2 lives from one family on October 17, 2018. Now, there is one question my co-counsel and I have been asking ourselves since before this trial ever began, and that is how? How can a parent take the life of their own child? It's crazy. It's irrational. It's absolutely insane. There are no words to describe the pain and the grief in our hearts, not only for, but with the Ray family and their loss. But it is within this pain and grief that we went searching for the truth. And in our search for the truth, we found Nathan's killer. We found the killer that is schizophrenia. Schizophrenia is the killer that has been pulling Tim in and out of reality with waves of anxiety, depression, delusions, hallucinations, paranoia, you name it. It's like the ocean that pulls a swimmer deeper and deeper into its depths until the swimmer is no longer able to scream out for help because the water is now trading places with the air inside their lungs and they're falling farther and farther below. And like the ocean, schizophrenia has the ability to rip us from the surface, sweep us under before we even know we need help. At the beginning of today's trial, the state promised to prove to you beyond a reasonable doubt that Tim intentionally killed his son. They promised to bring you proof that was so convincing you would be willing to rely and act on it without hesitation. But with each witness they called to the stand today, our hesitation only grew bigger and bigger and bigger. See, we heard from Detective Booth today, an investigator who was supposed to walk us through her case. But what we really learned from Detective Booth is that she's an investigator who can only remember bits and pieces of her training and policies from the academy. She's an investigator who called a sick member of our community a piece of shit who is better off dead. And when asked if this was the appropriate behavior, I wrote down her response because I thought it was that important. That's how I conduct my interviews. Detective Booth wants us to believe that Tim is not schizophrenic, even though she admitted on the stand today that she would not be able to recognize or identify signs of any mental illness, even if it was staring her right in the face. Now, the state also brought up some Google searches, members of the jury, and when we hear the phrase Google searches, I'd like for us to only think of 2 things. 1, the state could not provide one witness today to testify that Tim himself made those Google searches. And second, there was not one Google search asking how to fake a mental illness. They brought an expert today who they paid $14,250 to testify that Tim is malingering or faking his mental illness. We were all in the courtroom today when their expert agreed with me that there were reports showing Tim experienced childhood trauma, anxiety, depression, hostility, aggression. He was locking himself away for hours at a time, going more than a week without showering, not sleeping. He was seeing things that nobody else could see and hearing things that nobody else could hear, believing that people were listening in on his phone calls. Signs and symptoms all consistent with schizophrenia within the age range that schizophrenia develops. But their experts still said that he was malingering. And it was the only expert who testified today that Tim is malingering. But members of the jury, or weren't people in Tim's life reporting that he was not well? We wanted to make sure that you had the whole story and not bits and pieces of the truth of what happened back in October 2018. And in order to do this, we took up a burden of our own, a burden of clear and convincing evidence, which simply means highly probable that Tim was suffering from a severe mental disease at the time Nathan was killed, and that because of this severe mental disease, he could not appreciate the wrongfulness of his actions. We proved today that schizophrenia, Tim was suffering from schizophrenia at the time Nathan was killed, and that because of schizophrenia, Tim could not understand the nature nor the consequences of his actions. And we proved this by calling 2 witnesses of our own. We heard from Officer Wentz today, a witness who would normally be testifying on behalf of the state. However, because this interaction was unlike anything Officer Wentz had ever seen before, he testified on behalf of the defense. And when we break down Officer Wentz's testimony, we can see the range of emotions that schizophrenia controls within Tim's mind. See, Tim was paranoid, frantic, and argumentative at first. He was demanding Officer Wentz tell him if he's working with the CIA. And then his behavior changed, and he became more zombie-like, and he was no longer talking to Officer Wentz. He was more just talking to himself. And then he started doing a jumping jack. And right before he did another jumping jack, his head started shaking uncontrollably, and he put his hands over his ears like a little kid who was trying not to hear something. Members of the jury, this is just a brief glimpse into what Tim's life, his emotions, his experiences are like with undiagnosed and untreated schizophrenia. But we wanted to make sure we understood what schizophrenia was, and we called Dr. Riley to the stand today to inform us and walk us through her medical diagnosis of Tim, including his childhood, her 2010 evaluation, and the 9 years in between 2010 and today's case. She took us into the mind of a schizophrenic patient and explained how when schizophrenia says strangle him, kill him, our ability to act and react falters. Our memory falters. Schizophrenia has the ability to pull us deeper into insanity as the fabric of our reality unravels. Members of the jury, the law understands that tragedy is not limited in the forms that it takes. We understand that because we came together as a society and we asked ourselves, when our mind turns in on itself, who do we turn to? Members of the jury, it's you. We turn to you and we ask for justice, that Tim not be blamed for what schizophrenia did. Schizophrenia already stole one life from this community, and we are asking you to salvage what it is taking from another. Tim lost his son too. And nobody benefits when somebody is sick. We ask that you find Tim either not guilty or not guilty by reason of insanity, because those are the only verdicts today where the law and justice meet. Thank you.
Okay, go ahead, counsel.
That's it, ladies and gentlemen. Undiagnosed and untreated, that's the case. Members of the jury, let me tell you what we do know after today. We know the defendant strangled his son on October 17, 2018. We know what he searched on Google the day after he did that.
Objection, Your Honor, misstatement of the facts.
Overruled.
Yes, Your Honor.
We know what he searched on Google the day after he did that. How to get rid of a body. Will bleach destroy a body? Countries that don't extradite for murder charges. Then, we know he stuffed Nathan's body in a garbage bag and buried him in the woods where no one would ever find him. And you know what happened next, ladies and gentlemen? The defendant tried to evade the police. He lied to Officer Wentz, told him he didn't have his ID, until he was forced to tell the truth. Members of the jury, why is this all important? It's important because only when the defendant was confronted with the evidence that he killed his son, that's when he decided to report symptoms of schizophrenia. You know what that's called, ladies and gentlemen? It's called malingering. The defendant is making up symptoms of a mental illness to avoid the consequences for killing his son. Now, members of the jury, the defense said that Dr. LaGreca was the only expert to testify that the defendant was malingering. But let me remind you, this burden is on the defense. They have to prove the defendant is insane, not us. And even so, you heard Major Riley testify on the stand today that she agreed the defendant was exhibiting signs of malingering. Members of the jury return with the only verdict that is consistent with the law and supported by the evidence. Find the defendant guilty.
All right, good job, everybody. Judges, please complete your ballots. I'll ask that everybody stay on mute and your cameras off until everyone has submitted their ballots, or all the judges have submitted their ballots, and then we'll do brief comments. So judges, please let me know when all your ballots have been submitted.
This is Juror Augusto Carrero, mine submitted.
This is Priscilla. Juror Jimenez, mine is done too.
This is Juror Brian Lawler. I'm finished as well.
Okay, so judges, you can give, you gotta put your cameras on, that's fine. Judges, you can give one comment to each team for each side. But keep your comments to just one. Who wants to start? Go ahead.
I'll go first. This is Priscilla. Hi, everyone. Congratulations. This is obviously unprecedented time. So I think you guys on both sides did a really nice job of presenting. I myself am a medical malpractice attorney. I work at Klein Inspector. It's a plaintiff's firm. So we are trial lawyers, and I think you guys all did a really nice job. For the prosecution, one comment I would offer is sometimes you got answers that I think were helpful, even though they might not have been phrased exactly how you wanted them. So, instead of like pounding them for the exact answer that you wanted, maybe just listen and like work with the phrasing that they gave you. Although, also caveat, I was on trial team and my coaches always told me don't listen to anything the jurors say. So feel free to disregard everything. For the defense, again, also, I thought you guys did a wonderful job. One thing that I would focus on more is sort of the history of mental illness and, just hammering home like the insanity defense, because it's a very tricky issue and it's hard to bring all of it out in this short amount of time. But I thought you guys were both really good advocates, really nice presentation. I really liked how you were able to lower your voices and raise them and, just sort of engage the audience as much as possible because we're not face to face. So those are my limited comments, but great job.
Okay, I'll go next. My name is Brian Lawler. I'm a little confused on how to get my video up, but that's okay. Anyway, very well prepared, everybody, both prosecution and defense. You guys knew your case very well. Prosecution, you laid out the in a very logical manner your whole presentation throughout. Defense in general, I liked your sort of relaxed demeanor throughout. And I especially liked the cross-examination of Dr. LaGreca. I thought the use of the exhibit was masterful, and also the demeanor of the defense counsel when she kept saying, "We can agree." And sometimes we don't always have to attack as far as our demeanor in cross-examination. And I think the defense made good use of that sort of relaxed demeanor. But overall, listen, I'm very impressed. I thought you guys all did a great job, and I'm going to continue finishing my scoring because I'm having a little issues with the Zoom. But thank you.
Hey, my name's Chris Augusto Carrero. Just to let you know kind of the background that I'm coming from. I was a prosecutor for about 10 years, and now I handle criminal appeals and Medicaid appeals, and I'm in North Carolina. I wanted to, am I limited to one comment per team? Is that right?
Yes, that's right.
Okay. So I would say for prosecution, what's the most important thing here? One thing I would say is when you were doing the cross-examination of Officer Wentz, there were times where the questions you asked and the points that were brought out actually strengthened the defense's point of view, and some of the questions you asked seemed to be directed. It was almost like you were doing a direct examination of him rather than a cross-examination. And I know you guys, I think you have to be prepared for both sides. Is that right? So just keep in mind that I know it's easy to get confused when you've got to prep both sides. So just try to remember you only want to pull out those elements that are going to strengthen your case against the defendant. And then for the defense, I think that the undiagnosed, untreated, unexpected is very strong, and your kind of undertoned, laid back approach is very effective when you're dealing with your expert witnesses, which can get really heavy and bogged down. So great job, all four of you.
Okay, thank you. Great job, everybody. Thank you for the judges. And everybody can